I must thank Council first for the indulgence before we commence, and we do apologize for the delay, but it is beyond our control. Thank you.
Thank you, Justice Mhlanhla. Justices, we intend to cover the following topics. We'll firstly deal with the broadcasting digital migration process. And within that, I'll address the legislative framework. I'll deal with the key features of the BDM policy. And then I'll also deal with the nature of the minister's powers, particularly from the prism of MMA's and SOS's new argument on consultation, the 3135 argument. And then the next topic, I'll deal with the alleged procedural unfairness. And underneath that, I'll deal with the fact that consultation is not required, i.e. the minister was not required to consult. And then the second point will be that consultations were in any event undertaken. And I'm mindful of a few aspects that were raised with regard to certain features of the consultation and the timeline, particularly from the 5th of October. I'll also address that. Then I'll deal with the alleged violation of rights. And there are 3 rights in that section. There is the section 16 freedom of expression right, on which I don't intend to spend much time, because as the justices would have seen, Vodacom devotes a great portion of their heads to that particular topic. Then there is the section 27 right and the section 7.2. Then I will touch on the failure to observe public promises, then deal with alleged irrationality, and proceed to deal with remedy. And under remedy, I'm going to deal with 2 aspects. The first is that the relief that is sought is inappropriate. And the second, I will deal with the dangers of a kind of relief that was mooted in the court's interaction with our learned friend, Mr. Ferreira, which, if I understood correctly, it is something akin to setting a new ASO date coupled with a reporting duty of sorts. But I'll deal with it. Apologies, when I deal with the question of the remedy. It is quite important, having regard to the interactions between the court and our learned friends, to remind ourselves to go back to the basics regarding the BDM process. We know that this process, in terms of the electronic media decision in paragraph 9, this court says that it commenced with a consultative process embarked upon by the late former Minister of Communications, Dr. Ivy Matsepe-Kasebure, in 2005. And it culminated in the publication of the BDM policy of the 8th of September, 2008. And that's what throughout we refer to as the BDM policy. And it is quite important to stress the fact that the publication of that particular policy, as the court noted in paragraph 9, was preceded by a public consultation process. And I am going to illustrate with reference to the various iterations of the BDM policy per the amendment, that each was preceded by a public of consultation, and I'll illustrate how that connects with what is envisaged by section 3.1 and Section 3.5 of the ECA. And the point is going to be that what the section envisages is the making of a policy which if one makes in terms of 3.1 must be subjected to a consultation process in terms of 3.5. And all of the regulations, all of the policies, i.e. the BDM policy and the various iterations, comply with 3.1 and 3.5. And the submission would be that when the minister implements an aspect of a policy that has complied with 3.1 and 3.5, she is not making a policy, but she's simply exercising a power that is adjunct to the original source, which is not contested, as I understood, to be Section 85, 2B of the Constitution. And therefore, we will illustrate that the argument, the new argument, which SOS and MMA say they stumbled upon late yesterday, is also unhelpful. And if I may then, for purpose of the reference, we know that the BDM policy of 2008 is Annexure PR 24, which is in volume 3 at page 255. And that policy was amended 3 times. And it was amended as follows. The first amendment was published on the 7th of September, 2012. And that the court will find in Annexure PR 25 of volume 3, page 273. What the court will not find in the papers, which is something that we had to do in response to the new argument that we were told yesterday evening was going to be raised, the new 3.1 and 3.5 argument, which is nowhere in the heads, as Justice Majid correctly observed in the interaction with our learned friends. We then had to source the fact that that amendment was preceded by a government notice. That's government notice 954 of 19 August 2021. That's GG 345/38. That the court will not have in the papers because it wasn't an issue that was raised and it is thus not attached. And what that amendment will illustrate is that the minister in that notice indicated an intention to amend the BDM policy and invited persons who are interested to provide written comments on the proposed amendments. So in other words, we are now at step 2. I indicated step 1 was the publication of the original 2008 policy, which was preceded by public consultation. Then there is an amendment which is undertaken on the 7th of February, 2012. And perhaps we can call that the 2012 amendment, which is the first amendment. Then 10 days later, on the 17th of February, there was a second amendment which was published. And that is in terms of notice 124. And it's Government Gazette number 35051. And in terms of this amendment, it substituted all the paragraphs that were introduced in terms of the first amendment, the one of the 7th of February, 2012. So when that was substituted, then we left with the initial policy in its unamended form. Then on the 18th of March, 2015, and the court will find this in Annexure PR 7 in volume 3, page 304. there was the third and final amendment. And that was published on the 18th of March, 2015, and that is the 2015 amendment. But importantly, for purposes of this, of the new argument and properly locating the minister's power, is that that process too was preceded by a public participation process in terms of a notice with government. So it's government notice number 954 of 6 December 2013. It's GG 37120, which is not in the papers similarly. But the court will see that in terms of that notice, members of the public were invited to comment on that proposed amendment. And the significance of the policy having followed that route is something to which I will return shortly. We know that South Africa should have complied with an international obligation to migrate by 2015, and that as a result of a number of delays, that date was not met, and as a result, there are various difficulties which are set out in the papers resulting from the status quo and the need to expedite the finalization of digital migration as a process.
Mr. Mutau, sorry for interrupting you. Your protection time is up.
Yes, thank you, Jessica. And we submit that it is important before we get to even dealing with the ministerial power to appreciate the following facts. And we submit that what cannot be ignored is ETV's flip-flopping in the entire digital migration process.
Sorry, Mr. Mutau. Yes. Mr. Mutau, can I just take you back to your argument with regard to the policy framework and its amendments?
Yes.
And the public consultation process that preceded that. If I understand you correctly, is your argument that the public consultation process that preceded each amendment was then dispositive of the duty to consult? And that if the minister then sought to make any specific decision arising out of that policy, she was exempt from consulting. Well, not exempt, but she'd already consulted. And in particular, to the extent that the 2015 amendment provides that the minister can determine the switch-off date in consultation with cabinet. That would suggest that the minister was not obliged to consult with anybody other than cabinet. Is that a correct interpretation of that?
That's precisely the point.
And what do you say to the proposition that the cutoff date itself would have consequences for users? The policy may in general terms have consequences for users, but the cutoff date says to a user, well, this is when the right that you enjoy may come to an end. Are you saying that that process was not to be the subject of any consultation?
So what was it? Oh, it was your not getting in. Yeah.
Well, we should not read that to be collusion between the regulator and Vodacom in respect of issues of connectivity. Justice Kolapen, if I may just return to that issue, it is quite important, and I was going to take the court to the relevant paragraphs in Mutau to locate how this court has dealt with this very issue, not, of course, from the prism of the facts that are similar. But let me illustrate this point. Let's assume the minister, having consulted, and in the amendment where express provision is made for the fact that the ASO date will be decided only with consultation with cabinet, and there being no objection and there being no challenge to impugn the validity of that policy. What then remains as a question of implementation of that policy is an adjunct power to the source. It is not necessarily a policy decision-making process. Let me give you an example. If the minister had published a schedule that she is going to install in KZN, followed by the Eastern Cape, followed by the Free State, and so forth, then a disaster such as the unfortunate one that we experienced happened, which, as the minister says, impacted on her schedule to install in the Eastern Cape and KZN. I'm talking about the floods. The minister would change the implementation program. And in changing that implementation program, no one can seriously contend that an implementation project is not simply an exercise of a power that's adjunct to the original source of the power, but it is a process that has consequences for citizens or the residents of those provinces who reside in areas that were not so much affected, and who would say, well, they have certain rights and entitlements. And the minister can't exercise such a power because it wasn't preceded by 3.1 and 3.5. That would be, with respect, absurd. And for the same reason, we submit that if a minister exercises a power in the context where the steps are well known, and we know that the steps that are involved in digital migration comprise at least of the following. We know that the process commences with the switch on of the digital signals while the analog ones are on. And we know that for a period of time, there'll be dual illumination. Then we know that there's going to be a switch off. We know in terms of the papers, the initial plan was to do it on a phased basis, province by province, which is why we have provinces which have completed their switch off. And then we know that what would then follow is a switch off in the form of an ASO. But this also doesn't happen in a vacuum. It happens in a process that had been opened since 2015 for qualifying indigent homes or households to apply for this policy, to apply for government assistance. And perhaps while I'm on this point, I mean, the court would have seen that in the references that you were provided by our learned friend, Mr. Marcus, in respect of the promises, he stopped short of dealing with an accompanying provision and or requirement, which is that there was a qualifying criteria that stipulates the process of application, the post office being the place or the venue, and the amount, which started at 3,200 rands and it increased to 3,500 rands.
On that point, I'm not sure whether Justice Kolapen is still.
Yes, so then Justice Kolapen, to conclude with your question, which I've already answered in part. In that context, the decision to cut off and or the decision to implement or decide on an ASO, those are decisions that are not subject to consultation in terms of the proper interpretation of Section 85(2)(b) of the Constitution, from which prism the exercise of the power is in terms of Section 3.1, which is required to comply with 3.5. So we submit a further requirement akin to the one that has been advocated by our learned friends to say the decision is defective and or it is deficient on the basis of or for want of compliance with Section 3.1 and 3.5, with respect, doesn't find application. The minister could not have been expected to start a process anew because this, as we say, is a power that is adjunct to the exercise of the original power. And perhaps if I might just refer to the decision of Motau, because I think it will be quite helpful for this court. And I must indicate I'm not referring to it as the first case because of the surname, but simply because of the relevance of the principle that is invoked by the case. If I may start with paragraph 32 of the Motau decision, it says, this court says the following: nevertheless, the fact that a functionary performs a certain act in terms of an empowering legislation does not, without more, mean that the functionary is implementing legislation. This is evident from the fact that Section 85 contemplates a distinction between implementing national legislation under Section 85(2)(a) and performing any other executive function provided for in national legislation under Section 85(2)(e). As appears from a close reading of the provisions, the distinguishing feature is the verb implement in Section 85(2)(a), and the content of this distinction is discussed below. And if I may then take the court to paragraph 40 of that decision. This court said, special care must, however, be exercised when reliance is placed on this factor. While administrative powers more commonly flow from legislation, Paja's definition of administrative action expressly contemplates that the administrative power of organs of state may derive from a number of sources, including the Constitution. Conversely, and as borne out by Section 85(2)(e) of the Constitution, read with Section 1, Roman figure 1, AA of Paja, an executive power may be sourced in legislation. And if I may pause here, the fact that an executive power is sourced in legislation, the import is it doesn't in any way answer the question that, or yield a definitive response that it is administrative action and therefore Paja finds application together with its exacting standards from a consultation perspective. And we say that same analogy is present here for the reasons that I've already mentioned. And the last paragraph.
I don't want to take you to detract you too much from your argument, and I think you've spent a fair amount of time responding. So maybe I'll come back to that later if need be. Okay.
Well, perhaps I don't need to read the paragraph, but to complete that logic, if I can just ask the court to have regard to paragraph 38 of that judgment, because it then places into context the submission, and we submit that following that discipline of interpretation, it would be clear in our submission that, as was accepted by our learned friends for MMA and SOS, the original power or source of the power is Section 85 of the Constitution. Then through that, you get to Section 3.1, and 3.1 has to comply with 3.5. But it is important, if one has regard to 3.1, to say what is it that 3.1 requires to be subjected to public consultation for purposes of 3.5. And the court will recall the discussion between the old version and the updated version of Section 3, and in particular Section 3.5 of the ECA, that 3.1 tells you it's a policy, and we know that the policy is the BDM. And that was subjected to 3.5 in terms of our submissions that we've made. And we submit that, with respect, should provide a response to the attempt to hook a case on the newly found point that we were told was stumbled upon last night.
Mr. Mutau, on the consultation point,
yes.
The minister says she did not have to consult, but in any event she did. The response from the applicants is that was not a proper or true consultation. What do you say to that?
Well, it is important to understand, firstly, the prism. Justice Nhlanhla, if it is accepted that the duty to consult does not include the duty to consult on the ASO, in other words, the determination of that date, that is with respect relevant, because that colors the entirety of the argument that they're making. Because you will recall that the claim for this consultation, it is largely on the basis that you didn't consult us on the ASO. And by extension, the cutoff, which we say, if the determination of a cutoff date is an adjunct, and the determination of the date of the ASO is not a requirement that needs to be subjected to consultation, then the prism through which we enter this claim or any criticism for public consultations is then given context. And importantly, we submit for the court to have regard is, or are the following facts. I mean, we've touched on ETV's about 10 in the electronic media, which was lamented by this court. We've also touched in the papers about ETV's about 10 in this current litigation, which stems from the Telkom litigation. And the court would recall that what happened, or what transpired there in that case is Telkom instituted proceedings, which was in 3 parts, part A, part B, and part C. And ETV intervened as an applicant supporting an expedited completion of a digital migration process. And there was a specific date, the court will recall, that the date was the 30th of June, 2021. That was the date that everyone was aiming for. And as soon as that dispute became settled, they instituted these proceedings, which seeks to achieve the very opposite of what was sought in the other litigation, and on the strength of which they were admitted. Then we asked the court to also have regard to the following factor.
Mr. Mutau,
yes.
I wanted to ask to get to the registration issue.
Yes.
At some stage.
Yes, I will.
I wonder if I could raise it now. If one has regard to the fact that the minister was aware as early as February 2021, when the president made the announcement that ESO should be completed by March 2022, why did the minister wait until 5 August to make the statement that requesting people to register, especially in view of the fact that the previous registration process had stalled basically over the years? Why then decide at that stage to do it? And when the minister does that, gives those who are likely to qualify a period of 3 weeks to do so.
Yes, thanks for the question, Justice Nhlanhla. I think we've got to contextualize the registration process and separate that from installations, because you would have seen that there is that conflation. The fact that installations had stalled for a particular period doesn't mean that the period of registration was closed. That, with respect, is important because it gives the 6-year period in which it is clearly communicated that there is a need to register. It clearly communicates the fact that there is a criteria. It clearly spells out, not only in October of 2021, but it's clearly spelled out about the consequences of failure to obtain an STB. And it makes it clear that those who qualify must register to get the STB, and those who do not must purchase it. But to bring it...
Is there a reminder, say between 2015 and October 2021, was there any reminder issued reminding people to register, even if the installation is not done? How
Yes.
was there any communication done?
Yes, Justice, perhaps let me do that at the moment, because I was going to deal with that issue at a later stage. If I can ask the court to go to volume 3, page 311. There is a statement issued on the 10th of March 2015. And at page 312, there's the second unnumbered paragraph from the top. The court will see, this is in March of 2015, the department will consult with cabinet to determine and announce the analog switch on and switch off dates. We call upon key role players in the broadcasting fraternity to put behind them their differences and work together to deliver digital television to our people, thus ensuring universal access to broadcasting services in line with the Constitution. Then the department will provide further details of the distribution, and the amendment of the policy is to be clearly defined when the policy is published. Then on the 13th of May, on that same page, the South African Post Office issues a statement. The court will see the second unnumbered paragraph. This follows an announcement earlier in the year that South Africa will switch to digital migration transmissions early in 2022. And the court will recall the initial plan was for January, and it later moved. The country is preparing to migrate from analog to digital, and in order to receive signals on an ordinary analog TV, viewers will need STBs or digital enabled television sets to decode signals, and the benefits are set out. And specifically, government plans to switch the whole of South Africa to digital broadcasts by April next year. So, and I'm taking the court to these references to illustrate that it is inaccurate to simply say that the cutoff date should be viewed as a date that is simply sprung on the public in circumstances where there was nothing else that's done about registration. What would happen? First of all, sorry, the need to register, the qualification criteria, what would happen if registration does not occur, and or if a person does not obtain an STB. At 313, the court can just note the second unnumbered paragraph and the last unnumbered paragraph, because it communicates the same message. Then over the page, there's a statement at it's PR 29 of the 27th of June, 2021. The sixth unnumbered paragraph, the court will find a government's commitment, which is clearly defined again, that it's not everyone, it's simply in accordance with the criteria. And after read SABC future tied to failed migration, the second unnumbered paragraph, reference is made to the president's commitment regarding digital migration. And if I can then just proceed, I was simply illustrating that the digital migration communication and notices didn't pause. And there is no communication that says the need to register stopped. And there is also no complaint, as the court has seen in the papers. There is no complaint that parties could not register or there is also no complaint that there has been a blackout in respect of the areas where ASO has been implemented.
Mr. Matau, I don't think it's in doubt that there were indications of what was intended and that the migration would occur and so on. I think the point that is being made is that there's a difference between a long, involved, complicated process which had limped along for years and years, and a time when you finally announce to people it's happening and understand you must now register. And if you don't, you're going to lose a benefit that is very important. And I think you want to concentrate on that point, because that's the question that crisply arises here, whether the 3-week period was a rational basis for, as it were, bringing this whole process to fruition and to completion in respect of registration. And then you can deal with the question of shut-off. But perhaps that's the point you might want to assist us with.
Yes. Justice Untata, I think the importance and why I was approaching it from that angle is this. It is important to know what was transpiring prior to the 5th of October in respect of communications that were issued. And its relevance is the following. You recall, Justice Untata, that the question is not whether you had registered and there was a delay in installation because you registered in a particular year, but there has not been an installation of the STV. But the relevance is, if you are on the database, you are a relevant statistic for purposes of the cutoff date. The cutoff date being the 31st of October, because it then brings you in the category of persons that would qualify for installation prior to the 31st of March, which has now been extended by the Court to the 30th of June. So it is, we submit, a relevant factor, because if you look at the isolation,
but I think the question is much more this: who is being left behind, and were they placed on sufficient notice that and given enough time to register so that they would not be left behind? That's the question. The fact that some efforts were made and the process meandered along for years and years is part of the regrettable history here, but I'm not certain that that's at the heart of what is the problem in this case.
Well, Justice, perhaps might I just attempt to deal with it in two ways. The first is that viewed in isolation, in other words, if the question is, well, there was a notice that members of the public should register by the end of October, failing which, if they register subsequent to that date, their installation would take about between 3 to 6 months. That, without anything else, we would submit might perhaps raise an issue. But we with respect submit that when that announcement is made and there is a ramp up, of course, that is coupled with the responsibility to say, government doesn't say, we told you since 2015 to register. We are only telling you that the cutoff is in 3 weeks. They do that in conjunction with ramping up the notification process. But this is in a context of communication that has been going out. So it would be unfair, we submit, and not in accordance or consistent with the facts, to simply look at the announcement of the 5th of October and say, well, have the parties been given reasonable notice, i.e. have they been placed on sufficient notice that in 3 weeks' time, if they haven't registered by then, there are consequences, which are not that they will not get connected, but they'll get connected on a later date.
Mr. Matau,
So, yes.
Please complete your answer to Justice Unterhalse first.
Yes. And therefore, we would submit that it is important for the court to look at the question of the registration process that was open for the period commencing 2015, together with the various communications, and that the last call which is what the minister calls it in her statement, is reasonable, requiring to be viewed in the context that any delays have got no bearing on the registration. In other words, the registration was always open. The delay in installation has little, if any, relevance for purposes of determining the consequences of the announcement of the statement on the 5th of October. That's a submission, Justice.
Yes, thank you.
Thank you,
Mr.
Justice.
Matau, if we accept that the minister tried to give as much notice as possible, we have to link that to the purpose of the date, the purpose of the switch-off date. And you would accept also that the purpose of the date was to allow sufficient time for those people who had registered for set-up boxes to be provided with those boxes before the switch-off date.
Yes.
Now, what information did the minister have before her which justified the conclusion that the date of switch-off, which she had chosen, would allow for everybody to be registered by 31 October? Did she have sufficient information to make that decision about the switch-off date?
Well, Justice Theron, we would say the minister had the necessary information at her disposal, because this is not data that is collated within a 3-week period.
So tell us, Mr. Matau, what information did the minister have before her when she made that decision?
The minister had the following information. She was aware that the registration process had been open for a number of years. She was aware that registration is a reliable proxy through which you determine people who indicate an interest in taking up government subsidy. She has information that she is trying to work towards what had been announced as a goal date of the 31st of March, and that would require cutting off a date, but not necessarily depriving people who've always had that opportunity the ability to acquire a set of boxes if they so wish. And that based on that, she was alive to the fact that she needed to escalate and or heighten the process to be consistent with that last call. And based on the data that was available, coupled, Justice Theron, with the fact that there are aspects relating to self-migration, there are cheaper packages in the form of 29 rands as the court would have seen, which make it quite easy for people to self-migrate. And that's how the numbers have been moving from the high numbers that were envisaged to the numbers that responded.
Perhaps I can be more specific. What information did the minister have that people who had registered would get the set-up boxes by the cutoff date?
So, Justice, I'm not quite sure I follow the question. And perhaps if I might just explain my difficulty.
Yes.
The minister.
Let me try to put it in a different way.
Yes.
In order to ensure that there were no severe adverse effects at the time of the cutoff date, as many people as possible would have to have the set-up boxes, right? Yes. So what information did the minister have to ensure that that was not going to be a consequence, that the people who had registered got the STBs before the switch-off date?
Justice Theron, you'll recall from the papers, the question is the statistics in terms of people who had registered, the STBs that were available in stock, and it was clear on the evidence at that time that the number of STBs that were present exceeded the number of people that had registered. And there was also a backup. You recall from the papers, a commitment by industry role players like Telkom and the likes, who had said that should the numbers increase, they'll be prepared to come to the party to meet the corresponding increase in numbers. And this is all this information that is being obtained in that process between February, prior to the decision to announce a cutoff, because you'll recall, Justice Theron, as you put to one of our learned friends, was the issue of the goal date raised. And I assume the reason why you had asked that question is because it was quite important for the minister to assess from a readiness perspective whether the goal date, if it will be adopted as the final date for ASO, would not yield any negative consequences.
Mr. Matau, oh, my sister is still continuing. Please continue, my sister.
Thank you. Thank you, Justice. Mr. Ferreira, when he addressed the court, made reference to various numbers of statistics. I just don't recall the page now, but it was in volume 10, and it refers to 2.5 million households who had not registered for state assistance in respect of the set-top boxes. And he also referred to a number of 36% of the population, that is 5.7 million households. And he said it was irrational in those circumstances for the minister to choose the date that she did. What is your comment about that, Mr. Matau?
Justice Theron, at the risk of repeating the point, we accept, I would readily accept that perhaps there would be some ground or basis to advance an argument if there was only a period of 3 weeks that had been opened for registration. That I would readily consider and perhaps even concede from a reasonableness perspective. But what Mr. Ferreira is not saying, he's not saying those are households that were unaware of the registration process that had been opened since 2015. Those are households who would have wished to raise their hands, but they were deprived of that opportunity. Those statistics, with respect, do not quite gel with the facts of the case, because absent a showing that there are these numbers and that these numbers do require an STB as Vodacom deals with it, and I have no doubt that my learned friend for Vodacom will advance that point. Those we submit are simply statistics that do not inform the question whether the decision to make a final call, coupled with the supporting publication campaign or publicity campaign.
Yes, but that doesn't help the minister, Mr. Matau. The fact that we don't know, we might not know why they have not registered. We just know there's large numbers who have not.
Well, yes, but Justice Theron, isn't the question perhaps the opposite one? If the requirement for voting is registration, and registration is open, with respect, it doesn't follow from the fact that people who didn't register when the opportunity was available is somehow indicative of the irrationality of the requirement to cut off a date of registration. But simply to say...
Well, we would need to know if those people were aware of the registration process, that they had to register and where and when they could register in order to vote.
Yes, Justice Theron, that's why I'm saying we've referred, earlier on I've referred to the various publications and the communiques that starts from 2015.
And do you say, or does the minister say that was sufficient?
Yes, she says there is no reason not to accept the fact that the registration process that had been open since 2015 was sufficient. But she didn't simply stop there. For her own purposes, to ensure that she does her own process to conclude, she doesn't simply say, I'm cutting off in 3 weeks' time. She says, I am ramping up this communication strategy. I am announcing the cutoff. I am rehashing the need to register. And I'm also informing the public about the consequences of failure.
On a slightly different aspect, does the minister accept that she had an obligation to supply set-top boxes to all those who had registered by 31 October and to supply that before the switch-off date?
Yes, Justice Theron. Yes, the qualifying households who registered prior to the 31st of October, yes. I think it's common cause even on the papers.
Is it, please refer us to where it is on the papers that the minister could have complied with this obligation?
No, Justice Theron, you're recalling the statement of the 5th of October. I mean, I'll give you a reference at the moment. But in the statement of the 5th of October, government's promise, even in relation to the KZN principle, the department's case, or the minister's case, is that the promise that has been made in respect of qualifying households who registered prior to the 31st of October will be honored. There's no dispute about that. And in fact, that's the reason why the High Court decided that to protect that category of people, it was going to extend the 31st of March to the 30th of June. So there's no dispute, as I understand it, Justice, that people who, all the qualifying households who registered prior to the 31st of October are entitled to a set of boxes.
Yes. All that remains is for me to give you the reference in volume 10 that I was referring to, Mr. Mutau. It's 1039. That's just for your benefit.
Oh, yes.
Thank you, my sister, Justice Tree.
Before Justice Chikri comes in, Mr. Mutau, I know we are asking you questions, but just to alert you, your allocated time is finished. How much more time do you need besides our questions, just to deal with your own points?
If I can be afforded about 10 to 15 minutes, Justice, and then I'll be able to put across the essential points.
That's inclusive of our question time, or is that your points?
Well, yes, let's cater. I'm assuming I'll be able to speak for 10 and accommodate 5.
Okay.
In the form of questions.
That's fine. Thank you. I don't know whether Justice Chico would want to come in now, or we allow you to finish.
Yes, that's what I mean.
Can I come in now, Justice Mhlanhla, because it's a follow-up to my sister Theron, and she's covered some of the issues that I wanted to raise.
You may proceed, Justice Chico.
Mr. Mdau, I'm also concerned about the large numbers of the public that we are told have not registered. And I think my sister Theron asked you whether we know why citizens do not register, have not registered, or whether the minister knows why the citizens have not registered. But my question following up to that is whether the minister accepts or not that there's an obligation to make sure that the slow pace of registration is rectified. If the minister accepts that, what has been done so far, because surely the minister has been aware now, you keep on referring to 2015. Surely the minister has been aware all along that the pace of registration is slow. What has the minister done? And that question will arise if you accept that the minister had an obligation to rectify that. And after the recent definite decision by the minister that this process is going on, has there been any vigorous publicity campaign aimed at the public? I know I've asked you several questions, but it's in the interest of time, and I'd like you to cover them as effectively as you can.
Yes, thank you, Justice Chik. I think let me start with the last question. I think there was an acceptance in the interaction between our learned friend, Mr. Ferreira, and Justice Unterhalter, that the accelerated process of public awareness in the form of the publicity campaign had taken place. And in fact, if I have my note correctly, Mr. Ferreira didn't dispute, or rather accepted, the proposition that was put by Justice Unterhalter that there can't be any doubt that that kind of process suffices for purposes of an accelerated media campaign. And so that would be...
Sorry, interruption.
Yes.
Is it effective though, Mr. Mdau? I think my question is it effective?
Well, Justice Chite, from within the four corners of the papers, effective in our submission is, do people know that they have a right to apply and register? And do they know what the qualification criteria is? And if they know, why are they still delaying? Well, I was going to proceed on that basis that from the papers, there are various permutations that are outlined. The permutations, Justice Chite, you'll recall, explain even the process of self-migration, the various devices through which facilities are now accessed, and why it is that, for example, you would find in part of the papers that there are households that had registered for STBs, but when installation had to occur, they indicated that they no longer needed STBs. So there are variations. So the fact that there are numbers of people who didn't register does not, in and of itself, with respect, indicate that the number of people who would be interested in taking up government subsidy. Because government subsidy is available over the years. And we say it is a relevant consideration. You don't, with respect, measure that as against people's decision to take it up. But the question, we say, it's the reverse. Is there a package? Was the public notified about the subsidy? Were they afforded an opportunity to register? And other than those, did they exercise their duty of registering in order to access government subsidy? Those we submit are also relevant considerations, because the fact that a survey as opposed to a registration process would have been a better way, as contended for by our learned friends. We know that flies in the face of rationality, because whether there were other means through which this registration could have been done and or statistics obtained is neither here nor there for purposes of the rationality challenge. So
don't you think, though, we would not be asking you all these questions if we had been comforted through an affidavit from the minister that, look, this is what we've discovered, in spite of the fact that this process, and mind you, we're talking about a subsidy to indigent people. If we had information before us that says, well, in spite of the fact that this offer was made, we know that there was a delay, and we are saying to the court, part of the reason is that other people have self-migrated. Other people have simply not responded in spite of whatever. But this court would then be in a position to then say, well, you know, definitely the minister has done all that could be done. Specifically, when we are faced with millions of indigent people. And I think my questions are really, informed by that. We're sort of in the dark, and we've got the minister in front of us, and the minister is not able to assist us.
Well, Justice Chief, perhaps I think in fairness, if there had been an indication, let's say by the court, that a further affidavit is required in terms of which the minister provides updated statistics, that requirement, the court is entitled to request that affidavit to be filed. It could have requested or directed that it be filed prior to the hearing. It can also direct that it be filed after the argument, but before judgment is given. Because what that would give you, it would give you at best the numbers to say, are there any other numbers subsequent to the previous affidavit, and in respect of rate of installations, where is that particular process? But what that will have to do, it would have to be read from the prism of the papers, because the papers say, this is what was done. This is the ramping up. And the ramping up would also be relevant, not only for the numbers that registered prior to the 31st of October, but even those that registered subsequent to the 30th, also the 31st of October, or even after the filing of the previous affidavit. But what, with respect, Justice Chief, what that would give you, and I'm not for a second suggesting that the court should not be concerned or act cautiously with regard to the question of the update. I've indicated that there would be no difficulty with it, but what I'm trying to deal with and ensure that in the submission I'm making very clear, it is that any reporting requirement of the sort that is proposed and or sought by the applicants doesn't take into account the aspect of separation of powers, the intrusion, the inappropriateness of a supervisory order for the reasons that we've advanced in the heads.
Excuse me,
I alluded to the fact that...
Mr. Mutau.
Sorry to interrupt you. Oh,
Yes.
sorry, my sister. You may
Mr.
proceed.
Mutau, I just want to come in when you say that the court could have asked the minister to file their affidavit. We sent an answering of directions to the respondent, minister in particular, to file an answering affidavit. What we got was the answering affidavit that was filed in the High Court. We did not get, unless I'm mistaken, we did not get an updated answering affidavit that will deal with the issues that Justice Chikri has raised. Also the issues that I'd raised with, I think, Mr. Ferreira when he was arguing. Because we are also concerned about the issue of the updates, what is happening to date, all of those things. And in the affidavit that we had asked the minister to file, that is what could have been dealt with in the affidavit. So that was not done. So I just want to correct your statement. When you say you should have asked, we did.
Well, Justice Clanter, perhaps I didn't understand the import of the submission or of the proposition that is being put to me. And the point perhaps or the submission that I'm making to the court is the following, that the question of the current state of installations is a question that can be placed before the court after the hearing, but before the judgment. My clients are here. They hear that issue. I can't say anything beyond that.
Thank you.
Yes.
Mr. Mutau.
Yes, Justice Mutau.
Just to take you back a bit, you would appreciate that the thorny issue is the 3 weeks period that the minister has said. But your argument is that we should not look at what the minister said on the 5th of October in isolation to what has been happening for the last 7 years.
Yes.
Is it the case for the ETV or MMO that there was communication that the need to register had to stop, and also that there was a complaint that if there is no registration, there would be a blackout? It's that the case made in the papers?
No, Justice Mato. In fact, we make the point. We've made 2 points. We've said this is viewed in the context where there is no complaint that people say they were unable to register, and there is no complaint that people are saying where ASO has occurred there have been blackouts. So that is not the nub of the issue that we're dealing with, and we say that's the relevant context.
You see, my worry is, as you have correctly submitted, speaking for myself, that if one were to focus too intently on what the minister calls the last call, it can't be a last call when there has not been any calls before. There were calls for 7 years, and the assumption is that people are registering, are heeding to the call. So this call is saying those who have not registered, because you've been given sufficient time to register, please do so and register by the 31st of October. And thereafter, to use your words, will ramp up. It doesn't mean, if I understand your argument correctly, that there will be a blackout even after registration. So they will be accommodated, if I understand you.
No, just not talk. The statement has 2 implications. The first implication is that those who register by the 31st of October will get their STDs and they'll be able to be connected. Those who are not able to register by the 31st, but they register subsequent thereto, those people will be connected within a period of 3 to 6 months. And it is in that context that the High Court took a decision that, having regard to that policy that was taken, extend the ASO from the 31st of March to the 30th of June to ensure that the pre-31 October registrations are properly accommodated. So that is the commitment.
Now to the 31st of June or 30th of June, we left with practically, one would say, 40 to 50 days towards the end of June. If we look at the remaining time period, is that time period realistically achievable or not? And if not, what is it that can be done to ensure that the people are not left out in the dark?
Well, just what comes to mind is, we know that there has been an extension of the ASO to, as I've indicated, the 30th of June. The first aspect is perhaps an affidavit by the minister to give the court an indication of how many more people have registered, because the court will recall this now happens in a ramped up phase. So how many more people after the filing of the last affidavit have? So how many more people have registered? That's the first. And then the second would be, in light of that, the minister would have to indicate from an installation perspective. The High Court has given 2 periods, 30th of June and the end of September. Will those be achievable? And together with that, perhaps to also indicate in relation to the equipment, the additional STBs that would have had to be acquired if there is a need, because it is very possible that the registration numbers have not gone up. And it would perhaps even give context to the contentions that are in the papers about the fact that you've opened up registration doesn't mean people are necessarily interested in the package. And there's no evidence that they didn't know.
I wanted to ask you that question and link it with somewhere in the papers. I've seen that the ST boxes are lying somewhere at various post offices and looks like they have not been collected. Now, what do we make of that? Because assuming we are to entertain the 3-week period and say it is insufficient and call upon the minister to file an affidavit, if people are not keen to go to the post office to go and collect it, we would still be back to square one. And what does that do? What more can one say the minister must do? You can't direct people to go to the post office to go and collect those STB boxes.
No, we accept that proposition, but I think perhaps a balance or perhaps a sense of comfort, and you'll recall I indicated the difficulties of a supervisory order in the form proposed by the appellants and all of its dangers. But it is possible to accommodate a process in terms of which the latest statistics are provided, because it is from that which the court will get comfort that there is, we submit, absolutely no cause for concern, and there's absolutely no basis for this case. In other words, for any of the relief that is set out.
My concern is we have a process that started in 2008 and 2008 and thereabouts, and everybody and internationally is moving towards digital migration, and it seems there is a buy-in by all the stakeholders in the country, and the minister has barring
ETV.
With qualifications, have made various calls. And if a view is to prevail that there is to be a further delay, and what would be the date? The 30th June, it's just around the corner, it's not possible. We would consider the 30th of September, which the High Court postulated. And your opponents talk about 18 months or 2 years, if I read the papers correctly. And I don't know what more can we expect to be done. Please help me there. That's my concern.
Thank you, Justice Ntopo. I think there is a need to appreciate the importance of expedition. And I have no doubt that the court, in its concerns, has taken that into account, that there is a need to expedite and to finalize this process, but there is this particular aspect with which the court says it doesn't have the latest statistics, but within the parameters of the BDM process, one cannot contemplate a situation where, as the contention was made, that if the court were to build in the need for the minister to submit an affidavit, it would then mean rerunning the entire process in terms of 3.1 and 3.5. I mean, I must be heard clearly that the submission is not that we concede that would be appropriate. And we also do not accept that an order of the sort that is intrusive in terms of the separation of powers principle, where, let me give an example. If the court were to say, let's say people who have registered by December, just assuming there are 800, and the court were to say ASO can't proceed until those 800, let's say 800,000 people are registered, the immediate danger is apparent, because the court doesn't deal, and it is not equipped to deal with those dynamics that occur when installers go to a particular place and someone says, I no longer need this, or people have moved and so forth and so forth. So those are the dangers of that kind of order. And therefore the question would be, from a reasonableness perspective, if the court were minded to require a further affidavit, we submit that would and ought to give comfort to the court for purposes of being of the court having an assessment, and it perhaps can give the other parties an opportunity to make submissions thereon and bear that or take that into consideration in the order that it gives. So that way it strikes a balance. I mean, our main point, we've made our submissions. We don't think, we don't accept that a proper case has been made out. But given the concerns that are being raised and the Section 172 power that the court is able to exercise in crafting a remedy, these are the submissions that we are making that we hope that the court would find helpful through an additional provision of statistics. Then the court would then issue its judgment, because the court will be able to test the 2015 process that has been opened. The court will be able to test the last call. The court will be able to test the extension period that was granted by the High Court to 30th of June, and whether the minister on what has been done thus far has complied and or will comply. And then the court will see how many of people who registered post the 31st of October are there in relation to how much stock is left. We may just find that in fact, even those people are able to be accommodated such that there isn't any need, or there aren't numbers that might be left out, having regard to, Justice Matopo, your question, the number of STPs that are lying in the South African or different branches of the South African Post Office. So mine is a submission that seeks to move us forward with a view to balance the need of expeditious finalization of digital migration, given that it is an international imperative, versus this one last aspect, as I understand, from which the court requires comfort. And I'm quite not adverse in my submission to that particular process, subject to those checks and balances that I've submitted, the usurpation of powers and the separation of powers.
Justice Motlantla, I would like to raise, I know Mr. Mutau is way over time, but I'd like to raise a completely different aspect to the concerns raised by my colleagues, if I may. I share those concerns, Mr. Mutau, but I'd like to ask you something completely different. There's a forceful contention by the parties, particularly by MMA and SOS, that the timing of the date of this announcement, 5 October, is not coincidence. It is, in fact, cynical, in the sense that two things happened which are related to each other. First, the president announced end of March 2022 as the date for migration in the State of the Nation address. And then after that February State of the Nation address, there followed litigation. As you will recall, Judge Bakwa issued an interdict. There was ongoing litigation, and in September, late in September, there was a matter before for Re-J, where there was an order, but which allowed the spectrum auction to continue, which is the second aspect.
Yes.
So the applicants, in particular MMA and SOS, suggest, forcefully so, that what had prompted this sudden awakening from the Rip van Winkle slumber from 2015 in October 2021 is that there was the spectrum auction and there was a president's address, and they hint that the president's address was linked to the spectrum auction. They say this is a sign of arbitrariness, which as you would know is strongly indicative of irrationality. What do you say about that argument?
Thank you for the question, Justice Majid. The question or the submission we submit ignores a number of facts. It ignores the fact that the president's address was in February. But you, Justice Majid, you'll recall that the initial envisaged date was January 2022. So the president talks about March, which is not connected with that initial envisaged date. So if one simply from that perspective, the entire scheme of the argument falls. But secondly, the need to expedite the finalization of the process has been explained by the minister in the papers.
And that need is the spectrum auction.
Yes, there's a need. Yes, there's a need to auction the spectrum. But the various technological developments in terms of which South Africa is lagging behind, because there are other ICT facilities that cannot be accessed on account of the failure to auction the spectrum. Because Justice Majid, you'll recall that for digital migration to be completed, the spectrum has to be cleared. So that is a requirement. It doesn't matter how and when it is done. There's a need to clear that. ETV doesn't contest that it is entitled to remain there forever. We say they want to stay there through other means, but no one disputes that fact. And thus, as I indicated, because of the entry point to that argument being erroneous with respect, the entire steps of the argument that follows can't be sustained.
You see, I asked that question because right at the beginning, when I think my colleague Justice Mhlanhla asked you about whether the clock started ticking in October 2021 or 2015, you took us to some documents in the papers. I'm not going to rehash that. But what you'd read to us was a press statement from the department, from the minister, dated 2015, and then you took us to a statement by the Post Office 2021. Now, it couldn't escape my attention that there was nothing in between, or unless you can point us to anything between 2015 and 2021. And that, I'm just putting it no higher than that. That prima facie seemed to me to fortify the submission that the applicants make, that there was really a slumber from 2015 until 2021. And suddenly there was an awakening in October because of the presidential address, announcement, and the spectrum auction.
Sorry, Justice Majid. I mean, I had to move on to another point because of the question that was raised. That is not the entirety of the interactions or the actions that were taken by government in terms of the continuous communication of the need to register. The heads set out the process comprehensively regarding what transpired. But I must be clear, Justice Majid, I am not making a submission that something different did not happen in October 2021. I've got to be understood. That I accept, and that is the minister's case. And she explains why it is that she acted the way she did. And why it is, she explains also why she didn't just simply say, well, registration had been open. It would be reasonable for me to set the date of the 31st of October without doing anything more. She realized that there were lags in terms of installation, but people must know that this process that has been open for many years has to come to a close, and she can't just simply say that without taking accompanying steps to heighten the communication regarding the cutoff date or the last call. So, yeah, I mean, that's...
Thank you, Mr. Mutau.
Yes.
Mr. Mutau.
Yes, thank you.
Yes,
thank you, Justice Mhlanhla.
Taken more than enough. I just wanted to get clarity. At the moment, is it correct that we are still in the dual illumination period where you have both digital and analog in about 4 provinces in particular.
Yes, I would think so. I think Centec in its papers gives an update in terms of the switch off that have happened in other provinces. But let's just say for present purposes, without necessarily committing myself, because I haven't looked at that closely. But I would accept that.
Come 30 June, if nothing is done on the 30th of June, the analog system will be switched off.
Yes, that's my understanding.
Now, I'm more interested on those applicants that registered after the 31st of October, who were told that they would be supplied with set box 3 to 6 months after the cutoff date. That is now after.
Yes.
It was initially end of March. Now it will be end of June.
Well, for them would be September. Sorry, for them would be September.
Yes, but now
yes.
if SO is on the 30th of June, what is going to happen to them during this period of 6 months where they don't have the STPs? Is that a total darkness, TV darkness, or what?
Yes, Justice, as I understand, the minister's decision is those who didn't register by the 31st of October would take 3 to 6 months to be connected.
So they will be off basically for that period of 6 months.
Yes, they will be. That is assuming there are more numbers than there is stock that is available. Then in that period, and in a supplementary, I think the minister explains the ramping up that has happened, the fact that the other service providers have come on board and have committed to avail the additional set of boxes which are going to be procured locally or manufactured rather locally.
Now that is the applicants are concerned about that those applicants, yes, they registered after the 31st, but now they are going to end up not being given the set boxes within that period, and they will be in total, I don't know whether you call it TV darkness or what.
It's
that's
a blackout.
What's going to happen to them, basically.
It's Justice Mhlantla, the consequence is not because, or will not be because of the imposition of ASO or the cutoff, but one should bear in mind that there is no complaint in the papers that people were unable to register or people did not know that they needed to register and that there is going to be ASO, because it is part of the references to which I've referred the court plainly makes it simple that the failure to acquire an STP has those consequences that then you wouldn't be able to access the digital platform, which is the platform to which South Africa was going to move. So while I understand the import of the submission, with respect, I can't do any better than to illustrate or to refer to those facts, that there is no complaint about inability to register. There is no complaint about a darkness, at least insofar as where ASO has been concerned. And we are sitting then with a category of people who cannot point to any fault on the part of government. Because if they had taken advantage of the process that had been opened through 2015, i.e. they had complied with their obligations for purposes of indicating the need or an intention to benefit from the facility that was available, then it takes us back to the position of where someone needed to vote and they didn't register. And we submit that for that conclusion to be reached, it is for this court to have to say, from 2015, the registration process that remained open, coupled with the communication and the imbizos and the blitzes and everything that has been set out, actually comes to a naught, because those people who didn't register, they were totally unaware that there was a need to register. They were totally unaware that a digital migration will have these consequences for them. And that therefore, what simply has to happen is that in their case, you disregard everything else. You simply look at the 5th of October to the 31st of October and you say, well, this is too drastic a step. But those are not the facts.
Okay.
If my sister is
Yes,
done,
you may proceed.
Mr. Matau, is the minister rigidly inflexible about the 30th of June? Because if the last call for passengers in October, they will not make it for the 30th of June in terms of the set boxes. There was a call, they heeded to the call. Will they make it or will they not?
Well, Justice Matau, sorry, I apologize.
Sorry. And if they won't make it, how rigid or how flexible is the minister in accommodating them and other people who may want to climb on the bus and get registered? Because I would understand the minister has noble intentions to get everybody on board. And if everybody is to be on board, some degree of flexibility is required.
Thank you, Justice Matau.
We may debate about the times and everything else.
Yes, I think the starting point, Justice Matau, is there is no indication from the minister on the papers that she's not going to be able to meet the deadline of the 30th of June. I think that's a starting point. But the second submission that I've made, that perhaps that issue would be conclusively demonstrated, not only with reference to those who registered by the 31st of October, but those who registered after the 31st, having regard to what has been installed thus far and how much stock is available, and perhaps to what extent, if any, those who registered after the 31st of October are also able to benefit from the overflow of that stock. Because bear in mind, on the papers, there are more STBs than the number of people that have registered. So the nub of the submission is it is perhaps premature on the papers to contend as SMS, MMA and SOS seem to, because they do a numbers exercise, which we've illustrated in the papers, that they discount the resources that become available once ASO is achieved in the different provinces, who are then available to assist with the ramp up of the numbers. And on per the minister's last supplementary affidavit, the 31st, which has now been extended, there is no reason, or there is at least no indication on her part that she's not going to be able to meet that deadline. But the submission is perhaps taking into account the submission, the propositions that have been raised, that an additional affidavit by the minister would perhaps assist in giving the court comfort regarding where the actual numbers stand. But again, I qualify, subject to the purpose for which it is tendered.
You know, I have a problem if somebody in my village were to say to me, they heeded the last call by the minister in October, and come the end of June, they can't watch TV because they happen to have been on analog. And what do I say to them? No, I accept. No, Justice Matau, I accept. Okay, thanks. In fact, I think Justice Tiron asked me that question, and I said that is correct, because that is government's promise, and we say that is how the KZN principle is implicated. So there's no issue regarding the pre-31st of October registration and their entitlement to an STB prior to ASO. So I don't think there's any controversy regarding that set of people.
Justice Unterhalt, I think you.
I'm sorry, I just want to raise one point, if I may. And Mr. Matau, time is running against us, so if you could try and be brief, it would be very helpful. Mr. Ferreira didn't accept this proposition, but assuming it were the case that the further opportunity that arose for registration after the 31st of October, let us say until the end of December, might have constituted an adequate period to afford people a chance to register. In other words, against your claim that the 31st was good enough, let us say a somewhat longer period is good enough.
Yes.
What is your position on an order that simply said anybody who registered, let us say, up to the 31st of December, must have their set-top box installed, or at least somebody must show to attempt to do so, and only thereafter can there be a switch out? In other words, if the minister's undertaking is to connect those who registered properly, and let us accept for the purposes of this question that properly means until the 31st of December, what would be wrong with an order of that kind? In other words, don't determine a fixed date for the switch out, simply impose an obligation on the minister to say, you'll connect those who registered by a certain date.
Well, again, two answers, Justice Unterhalter. You recall that the minister's supplementary affidavit was filed way after December. So as the court, at the moment, you have the numbers post the 31st of October, at least up until the time when the supplementary was filed at the hearing of the court. So I'm not sure whether Justice Unterhalter is asking me that proposition with that in mind, because those numbers are there up until then. What we don't have would be numbers of registration after, if any, after the filing of the supplementary affidavit. And what would also be missing would be—
But Mr. Mittal, let's not get caught up in numbers. Assuming we take the numbers that appear in the supplementary affidavit as the number of people who registered after the 31st, up to the filing of that affidavit. If an order was issued that said, well, those are the people who must be connected, and only once connected can you do the switch out, what's wrong with that?
Well, let me perhaps then deal with the second part of my submission, which is what I had earlier dealt with. The difficulty with that kind of an order, Justice Unterhalter, just if framed in those terms, is that it's going to take a particular number and link the particular number as a jurisdictional prerequisite for ASO. And to the extent that there are difficulties, per what I illustrated, assume 1,000 of those people who are on that list, for some or other reason, cannot be connected. Either they've moved or they've expressed.
One can create an order that says reasonable efforts to connect.
Well, Justice Unterhalter, in other words, as I understand, that would do away with the need for any further material to be filed before the court, because I'm just trying to understand.
Yes, in other words, you take a period, you say, assuming against the case that you've put up. I'm not saying you're wrong, but just so that we can see where it goes.
Yes.
You say a period of X after the 31st of October was required. We will treat all of those who registered in that period as people who are entitled to be connected. And then the minister must simply make reasonable efforts to connect them. And once that is done, she can switch out.
And perhaps this is what I was battling with, just to understand the proposition. Then is it at her sole discretion to determine that she has made reasonable effort, or is there some process that is built in? If it is just that without more, Justice Unterhalter, I mean, the court's power in terms of section 172 might be invoked in those terms, because it avoids a usurpation and or an infringement or intrusion into the separation of powers. Then, because for me it's important before I make that submission and or concession to understand what that would mean. But if that's an order that doesn't have anything that's built into it in terms of the interaction between the court supervising that particular process.
It's simply take reasonable steps to connect those who registered in the period. That's what the order says.
Yes, Justice Unterhalter, Might I just do this? I will take an instruction.
Certainly.
During, yes, and perhaps just come back after I reply, just simply to indicate my
yes, thank you very much.
Yes.
Thank you,
but,
Justice.
But Justice Ndant, if I understand properly, the type of proposition which doesn't necessarily indicate the direction that the court is going, but what you're asking is if there is to be a period that is taken to say people who would have registered by this particular period, and those are the people that the minister should make a reasonable effort to connect. And speaking for myself, I can't see any difficulty, but let me speak to my client.
Yes, thank you very much.
Thank you.
Yes, as the people who implement, they may just raise things that I'm not aware of.
Sorry,
we are way over.
Justice Ndantla, can I just complicate that just to complete it so that we have some clarity? Thank you, and I'll be very brief. I think that is quite useful in terms of taking instruction, but that leaves the category of people who have registered post-December until March. And there's also a commitment by the minister to have them onto the system by September. So I think if you do come back to us, it would be useful to deal with that in its entirety, because there is an obligation. There is an obligation to deal with those who registered up to March, if I understand it. That's about 250,000 people, households, sorry.
Yes, but Justice Corbin, you'll recall that even in terms of the order, that second category, the court said they must be registered by September, but it doesn't say that ASO can't occur.
Okay.
In respect of that.
No, good. If September is still the date, that would take care of that. Then thank you.
Okay. Yes.
Thank you, Mr. Mutau.
Thank you, Justin.
Mr. Snakers.
Thank you, Joseph Huntler. Justices, as indicated in our heads, Vodacom's concern is solely with a specific aspect of the interdictory relief sought against the minister, that which prevents the minister from declaring ASO unless and until a quantitative threshold of some sort has been reached with respect to the delivery of STBs. That relief calls for an entirely inappropriate intervention by this court, which is not justified by the appellants, for which the elements have not been made out, and which rests squarely on two insupportable foundations. The first is the notion that an enforceable pseudo-contractual right was created by a government promise based on misapplication of the KZN decision, legally and factually. And the second is wholly inapposite invocation of a supposed infringement of the right of freedom of expression. Now, this latter invocation is misplaced for two fundamental reasons. Firstly, it conflates the right of freedom of expression with one of its modes of its enjoyment, and fundamentally with the means to be able to enjoy this particular mode fully. It then turns this into a socioeconomic right, which, because it is not found in the Constitution, among other socioeconomic rights, requires tenuous and wholly implausible recourse to the generic socioeconomic right to social assistance, which is housed in Section 27. And then secondly, because this right of freedom of expression itself is in no way being restricted, the argument invokes the notion of retrogressive steps in relation to the existing enjoyment of socioeconomic rights. The argument begs the question whether the conduct at issue is not a retrogressive step at all, but a progressive step with respect to the same rights holders in relation to the furtherance of the means to enjoy the same right, namely freedom of expression, if by different means, where these are means that lie at least arguably more closely to the core of the communication activities engaged in by those rights holders. Now, the right that was relied on for the purposes of the interdict, first of all, is the KZN principle, and that's dealt with in our heads in paragraph 42 and following, page 24. Heavy reliance on this by ETV. The interveners do not even mention it in their heads, and it is so undeniably not helpful for the appellant's case that is why they don't. The basic principle that was established in that case is that whatever the content of the actual promise was, and in the ministers in its heads and in papers, and we in our heads and papers have in detail shown that is not what ETV contends it was. Whatever the content of that promise was, the government was free to withdraw this promise at any time before it, quote, crystallized, in the language of the majority of this court, into a due date for performance on the part of the government. That is the general basic principle. We're not saying it's confined to the facts of KZN. It is not extended, that principle was not extended beyond this by Pretorius. Now, the only due date at issue in ETV's case can be the ASO date. And if the promise was to supply everyone with an STB by ASO, then the due date would be ASO, which had not arrived by the time of the alleged reneging. And that is the end with respect of the KZN principle. It is, in any event, important to point out that on the facts, the content of the promise, one must distinguish promises, actual promises, from political commitments, such as housing for all, nobody will be left behind. These are aspirational commitments, not promises in the KZN sense. There was no promise that there will be no ASO unless and until everyone had set-top boxes, or everyone who qualified had a set-top box, or until some nebulous stage of sufficiency in set-top boxes had been reached. That takes us to the freedom of expression right invoked and the taking of a retrogressive step. We deal with this in our heads at paragraph 53 and following. The cases cited by the appellants are about the importance of freedom of expression and are cases where there's an undeniable prohibition of freedom of expression, including the freedom to receive information. Here, there is no such prohibition. ETV is still allowed to broadcast, the viewers are still allowed to receive. Technology has changed with the digital migration policy. People now need different devices to continue exercising the right. They've always needed devices to exercise the right. There is no suggestion that a person who can afford digital television or an S-top box has her freedom of speech impaired by this. This is a telltale insight into the need to turn to socioeconomic rights. The means to pay for it is at issue, not the right to freedom of expression. That's the case with respect with all socioeconomic rights. They unlock true enjoyment in the sense of positive freedom of other more orthodox civil and political rights, such as freedom of expression. But they do not equal. Some are enumerated and have their own special rules and formulations, housing, water, education, and one is generic, social assistance. Assisting with the means can enter the right of freedom of expression only through this avenue in our constitutional order, and that is critical. But this raises a serious problem. For obvious reasons, these rights, to which people have a right to progressive realization only, not to immediate fulfillment, as with the negative civil and political rights, where they have a right to immediate fulfillment, these rights apply in the case of the right to social assistance, to basic needs only, to necessities of life, the cases that we set out in paragraph 60, Khoza and Mahlangu. Here, an ostensible right is set up to specific television content via digital access. That can never, with respect, be a basic need. Those without televisions don't enjoy this ostensible and peculiar right. Nobody suggested that there is a right to be provided with a television. Yet those who do not have televisions are more deprived of the right to access ETV television through digital technology than those the appellants concern themselves with. You need to have a television and the wrong one to qualify for this socioeconomic right. There is, and this is critical, there is no right to TV access as such. There was an attempt to suggest that there's case law that suggests there is such a right. The Moldova decision, an SOS case that is referred to by the interveners, those cases refer to the duty on the state to expose the public via the public broadcaster to access to pluralist views, including on television. That very right is captured in our section 192 of the Constitution. It has, with great respect, nothing at all to do with making people get the means to pay for television. Section 192 is, in fact, specifically dealt with as what its confines are by this court and its majority in the Mnet and ETV decision. If I can just read in paragraph 70 what the majority said in that regard. Section 192 of the Constitution has got very little, if anything, to do with the minister's exercise of her policy-making powers. It explains the existence of ICASA, the constitutional obligations it bears, and the guarantee of its independence. Properly understood, this provision informs us that ICASA is an independent authority whose mandate is to regulate broadcasting for the good of the public. When unfair reporting or a biased or inexcusable exclusion of some views happens, it is to ICASA that any aggrieved party may turn to lodge a complaint for possible intervention. ICASA is also constitutionally enjoined to level the broadcasting playing field so that a diversity of views that broadly reflects the thinking of South African people, as opposed to one-sided propaganda-like narratives, may find expression. To seek to source the bases for the alleged procedural or substantive irrationality of the minister's policy determination from this section would, to say the least, be an unfortunate misapplication of the provision. And it would be a similarly unfortunate misapplication of the provision if one wanted to source some sort of socioeconomic right in relation to particular TV content from that particular right. That, with respect, should be the end of the invocation of the case law surrounding retrogressive steps with respect to the actual enjoyment of socioeconomic rights. Those cases deal with removals of the right of the enjoyment of the actual relevant socioeconomic right itself, not with blue rights that it may be said indirectly to further. The right to housing, for example, in Jafta or Grootboom. The clue into the sleight of hand we set out in our heads in paragraph 40.3 at page 23. The conduct of progressive realization is identified as the provision of STBs by government. This is the progressive realization, the positive side of it. Quote, the allocation of public benefits to access digital television broadcasting, unquote. This, of course, suggests that the retrogressive step would be the removal of an STB already being enjoyed, or at a stretch, stopping the provision of STBs. Yes, that's not an issue. Nobody's STBs are being removed, and everybody's going to get one. Everybody who qualifies will get one, whether tomorrow, whether next year, whether the year after, everybody's going to get one. The retrogressive step, however, now becomes nothing to do with STBs, but ASO, a move said to have a negative effect on freedom of expression, rather than on any social assistance right associated with it. This simply misapplies our constitutional jurisprudence. So I can have an analogy. Section 21 guarantees everyone the freedom of movement. People need transport to enjoy this right effectively. A new fuel technology is introduced to cater for environmental imperatives that everyone agrees is a critical imperative for the enjoyment of various rights. This makes transport much more expensive. Government may or may not have an obligation to assist people to pay for the new fuel. That would be on the socioeconomic side of things. But neither the introduction of the new fuel nor declining to offer social assistance in this regard is an infringement of the right of freedom of movement. Hence, the invocation of an infringement of freedom of expression via the retrogressive step jurisprudence is stillborn. But assume it can be applied in the present case. Assume one can ignore the conflation of the blue right with the associated socioeconomic right being invoked. Then one must recognize this. None of the cases of retrogressive steps in the socioeconomic right jurisprudence deal with a step that furthers the same underlying right for the same people. They all deal with undeniable removal of the right for those people. In our case, however, we have contending ways of enjoying freedom of expression by the same people through passive reception of ETV's television content or through active and passive communication through cellular telephony. And we then have a step.
Mr. Snakers, your protection time is up. You may carry on. Mindful of the fact that questions may come in.
I shall be mindful. Through passive reception of ETV's television content or through active and passive communication through cellular telephony. And we then have a step taken deep in the core of the sphere of executive policy, as recognized by this court in Mnet and ETV, specifically relating to the digital migration policy, that chooses to use a scarce public resource, the use of which is mutually exclusive for the two methods of communication, in a way that would further one mode of enjoyment, cellular telephony, rather than another, reception of ETV's television content through analog. The Constitution does not and cannot tell this court whether this choice is a retrogressive step in relation to the effective realization of the right to freedom of expression. It certainly, at least arguably, is a progressive step for the same people in question.
Sorry to interrupt you.
Yes, Justice Strong.
Does Vodacom accept that the minister's decision denudes existing rights or denudes the exercise of the right to receive information, the existing exercise of that right?
No, Justice Strong, that's the point. What it does is it begs the question whether there is a denudation of that right when it's viewed as a socioeconomic right in relation to the means. And then you have to ask yourself, in a situation where you take a step that is aimed at furthering that right, or at least arguably has that consequence for the same people who are at issue, the same right, is that now a retrogressive step or not? And that's why those cases are all distinguishable. There is no retrogressive step.
Doesn't it further, well, immediately, doesn't it further the right for some people and limit the right for others?
No, Justice Strong, because it's the same people. It's the same people who are the poor and have television sets, whose rights to cellular telephony are being promoted. It is the same, and the ubiquity of the cell phone holding is not disputed. And so the right to freedom of expression is being furthered for the same people, the same right for the same people. And there are two, if one looks at, there are two cases that are perhaps useful in this regard. The closest analogy is one is Mazibuko, the water case that is 2010. Our learned friend Mr. Mark has also referred to it, 2010 4-1 CC, the right to access to water. If one looks at paragraphs 135 to 147, the court considered whether on the facts a new method of providing the same citizens with the right to water could be seen as a retrogressive step in relation to the actual enjoyment of the right to access to water, and found that it could not be. And also, importantly, in the COVID case in the High Court, it was a full bench of the Johannesburg High Court in One South Africa Movement and President of the RSA, 2020 5 SA 576 GP, paragraph 91. The court was very astute to see that the right to life, which was being invoked, was pointed in different directions in relation to the very same people who were invoking it, in relation to whether the COVID measures that were being pulled furthered or hindered the right to life. And that meant that one didn't have a situation that required an analysis under the justification clause, because you can't be speaking in those situations of an infringement. Now,
Mr. Snakers, if the state decided to close down all public libraries, would this decision limit the rights in Section 16 to receive information?
It's an interesting question, Justice Theron, in that all it would amount to would be the shutting off of a particular channel of freedom of expression. But that would also not be a violation of the right to freedom of expression. There is in any event here not a shutting off of a channel. That's the important point. That's why they need to rely on socioeconomic rights. Isn't there a
shutting off for a large part of the population?
No, there's no shutting off. All that happens is that there's a new technology that means that some people are now less able to afford a particular means of accessing TV than before. In other words, nothing's being shut off for anybody. And that's why I gave the example of a new fuel. And that is why this has to be viewed for the appellants. The case has to be viewed through the lens of socioeconomic rights, because there's no direct link to the right of the enjoyment of freedom of expression. So you're not dealing here with a situation where they say you're no longer allowed to have analog to have television. It's a new technology. A new technology has come in, and it involves cost. And the question is, must the government now subsidize that cost, or must it not? And that may or may not involve socioeconomic rights. We say it's a stretch. It's a stretch beyond where Section 27 can ever be said to go. But it has nothing to do with a direct infringement or a retrogressive step in relation to the enjoyment of free speech.
Yes. My last question, Mr. Snakers, sorry. Part of Vodacom's argument is that the minister's decision does not limit the right to free speech because it will free up the spectrum, which will have free speech enhancing effects. What do you mean by that, and why is that important?
Well, the two things, Justice Tron. The first is that you have a step that on an analysis, if one is starting to ask oneself, does the step have an effect on the effective ability of people to communicate? Because that's what freedom of expression is about, the effective ability of people to communicate. Then one knows that on the other side of the equation, in other words, on the other side of the people who want access to digital ETV content, are those who use cell phones. And that includes most, if not all, of the same people whose rights the appellants invoke. And in a nutshell, the benefit to them of the freeing up of the 700 and 800 spectrum with its unique coverage and penetration capabilities, especially in rural areas, is cheaper communication. So this is, after all, the main drive behind government's policy of bridging the gap.
No, I'm going to stay up with you. Yeah, I don't want to sleep yet now.
Ms. Lekokotla, please mute yourself. Ms. Lekokotla, please mute yourself.
So this respect, the benefit is freeing up this particular spectrum. And that's an issue on the other side of the spectrum of that, which is access.
Mr. Sneakers, just check your connection. There's something wrong. There's a background noise that is coming out.
Justice Mutata, I believe that was the background noise that had come through. Is it off now?
It's still bad. It's quite bad. Justice Teron, and where's Zunate? Please assist. Just try again, Mr. Sneakers.
Is it still? I can't hear any background noise.
That's better. That's better.
It may have been because of the interference we had, Justice.
Yes.
Sorry, I'm not sure if my sister Justice Teron is done.
Looks like
it. Just continue with the answer to the question, if you may. The evidence of the benefits to the poor and South African citizenry as a whole are undisputed and extensive in the papers. There's an incredible congestion and a spectrum squeeze for cellular operators, and an urgent need to free up spectrum, especially on the 700 and 800 with its greater coverage and penetration capabilities. And this is critical for rural coverage and for ICASA's license requirements for coverage obligations. Can I just give a couple of references beyond what's in our heads of what is critical in this regard in the papers? We have those references that are on paragraph 73 of our heads. I'm not going to refer to those. And then in addition, the following are references in the papers that are either not disputed by ETV or actually expressly not disputed by the interveners. Paragraph 74 of Vodacom's answering affidavit, volume 8, page 865. The spectrum constraints are one of the biggest obstacles to the lowering cost of communication. This imperative directly affects the freedom of expression rights of millions, far more basically and directly than ETV content. The increasing constraints on spectrum directly affect the ability of consumers to communicate effectively and cheaply. That is not disputed by ETV. Their seriatim portion starts at volume 20, page 2122, and it skips this paragraph. In the answering affidavit to the interveners, paragraphs 15 to 16, the coverage requirements for certain portions of the auction 700 and 800 spectrum from the auction, 97 to 99% access to good mobile and broadband services, delaying the rollout of the 700 and 800, delaying its availability, would achieve a significant delay in the ability to achieve these targets and in lowering data per gigabyte. The longer the delay, the longer the people are deprived of this benefit. This is expressly not disputed and in fact supported by the interveners in their replying affidavit to Vodacom, volume 19, paragraph 17, page 2050, including the reduction of data prices. And then again, paragraph 33, page 1779, the viewers themselves would benefit from increased coverage, speed, and lower prices. In other words, the viewers that are at issue here, they would benefit from increased coverage, speed, and lower prices, and that we say that it wasn't addressed by the interveners. The interveners reply to that, and they say they do not dispute these allegations in paragraph 33. So that in volume 19, 2057, paragraph 39. That is on this side of the equation in relation to a contestation about use made of a particular scarce resource for the same people to further freedom of speech. What is on the other end of the equation? We deal with these two groups in our heads at page 33. Those persons not too poor to own a television. That's quite important. Who own a television, but the wrong television, who cannot afford a digital television or the once-off payment for an STB, some 599 Rand, we told in the papers, who are ETV viewers, I'll get to that, who reside in those provinces where ASO has not yet occurred, and who have failed to register for STBs despite a window of over 6 years to have done so. That's the group whose rights are supposedly being violated. They must be ETV viewers, not SABC viewers. We deal with this in our heads on paragraph 68.2. ETV is an English language channel only, and the SABC is voluntarily switching off. There's no interdict was sought against the SABC at any stage by anyone, interveners or ETV, at any stage, either to demand that they switch back on or to say you can't switch off. Both ETV and the interveners, and this is quite important, both of them actually make a virtue of the SABC switch off as freeing up spectrum in 700 and 800 for ETV transmitters. I give you the references to ETVs making this a virtue. That's a paragraph 68.2.5 of our heads. And the interveners do that themselves as well. In their replying affidavit to Vodacom, volume 19, paragraph 11.4, page 2045. So there can be no suggestion here, and this is very important that this not be left out of account. There can be no suggestion here that people are purporting to speak on behalf of either the SABC or their viewers. And on the other side of the equation, we have seen that the benefits for everyone in cheaper cell phone telephony. So,
Mr. Snickers, can we say that reducing the cost of cell phone calls promotes free speech, but imposing costs on television viewers does not limit that right?
Justice Tron, that's the point with respect that we're making, which is that we cannot say that. But you, with respect as the court, can't say that the Constitution answers that question for the executive one way or the other. If it did answer that question one way or the other, you could then start speaking about retrogressive steps and the introduction of that jurisprudence. It doesn't. This is a decision that falls squarely within the kinds of decisions that the executive is entitled to make and should make, and that it is the duty of this court to respect. We can't say whether the right to cheaper telephony is closer to the core than the right to receive a very particular privately offered television content through a very particular means. We do say, and with respect, I don't put this flippantly, we do say that that right that we invoke has at least arguably a greater claim to being closer to core communication than the right that is invoked by ETV and SOS. But what we stress that it is not necessary for this court to answer this question, and in fact that the court should not answer that question. That is the question that is for the executive as a matter of policy to answer. And the conclusions of this.
Thank you, Mr. Snickers. I agree with you that this case is not about a competition between, as it were, which form of access to information is the preferred one or the one that advances development in our society. But having said that, I think there's an agreement between the parties that the migration from analog to digital is generally a progressive one. At the same time, there's a commitment by government that in the process of that migration, those who cannot afford the cost of that migration will be assisted. And that's clear as far back as 2012. So it would seem to me that without creating a competition between rights, but in the context of freedom of expression, ideally, and in an ideal world, there should be a seamless transition. As you move to the new technology, you bring those who need to be onto the new technology along with you, and you subsidize them in accordance with government policy and a government commitment. And perhaps therein lies the crunch, that if indeed the method of migration is going to have the effect of leaving those behind, its effect will indeed be to deprive them of an existing means by which they were able to access information, and information relevant to various aspects of their life, including their healthcare, including living a better quality life. So it's just not a question of freedom of expression for the sake of receiving information. And perhaps in that regard, what is your view with regard to ensuring that indeed the transition is a seamless one, that the progressive steps taken do not result in unintended consequences of leaving others behind, and in particular your comment on the debate we had with counsel for the minister with regard to practical measures that could be taken to ensure that that transition was as seamless as possible.
Mrs. Colopin, this is, you've touched on a very critical issue that that is at the heart of our concern with respect in relation to the interdictory relief. First, draw a distinction between the review relief and the interdictory relief. If a decision is made that affects people and there's a problem in relation to procedural fairness or rationality, etc., the remedy is to set that decision aside unless that's not a good remedy in the circumstances. That's not what I'm dealing with. I'm dealing with the interdictory relief that says you cannot have ASO unless and until you have achieved a certain level of STBs. And that they seek to ground in a socioeconomic right to the STBs and or in the KZN principle. That's the only place they can find it. Now, if the KZN principle doesn't give them that right, and we see it doesn't, and with respect, one can't seriously suggest that it does, then you have this very serious problem when it comes to the STB provision. There is no problem. Let us assume for a moment, let's assume for a moment that one can translate governmental obligations in this sphere into some kind of obligation to give assistance. Let's assume that. So in other words, although it's a matter of means, and although nobody can suggest this is a basic need, let's assume that there is an obligation to do something effective as far as assistance is concerned on the STB side. And let us even assume that there is a finding that not enough is being done in that regard, and that government should tell us how much more it's going to do and when it's going to do it and the like, and that it's a good idea for them to come and tell us that. Let us make all those assumptions. That doesn't begin to translate into a basis for an interdict against government to say, unless and until you've done various things on this score up to a certain level, you cannot have your ASO. That is with
inadequacy in delivering on the positive side into a paralysis of the ability to exercise a critically important executive function and right.
Well, if you're saying that goes too far, what are you willing to say how far relief should go in the event that this court should find that there's a basis to review and set aside?
So if the court were to find, with respect to the decision either of the date itself or of the cutoff with respect to registration by a certain date, in any of those, if it were to find that that was sufficiently unlawful, whether for irrationality or procedural bases, to warrant a setting aside of that decision, then that is what it should do. If it were to find that there is a warrant on the socioeconomic side of things for an order that, for want of a better term, hurries the government along in delivering set-top boxes, it can do so. The one thing it cannot do, without a basis in constitutional law for it, is to say, government, thou shalt not have ASO unless and until you've done these things. There is no basis for that. There is no basis for saying, although it may well be, the court may well think that that would be a fantastically effective whip. But that, with respect, one cannot, the court can't say, because I think this would be an effective disciplining mechanism, I will interdict government from performing an executive function unless and until it has achieved a particular threshold in relation to fulfillment of a socioeconomic obligation. That it can't do. So by all means, with respect, have them report. By all means, say 100,000 a month isn't enough. 200,000 a month isn't enough. You'd need a lot of evidence to know what's going on, what's good, what's bad, how many people are still out there. Is this a good way of communicating? But that doesn't begin to translate into saying, unless and until we have hit some level of satisfaction, you can't have your ASO. Have the ASO. And if people need to be assisted with ASO in place in certain ways to get those set-top boxes and to get the means in the way the court has done in numerous other cases, you don't then go and interdict government from doing something important that has nothing to do with whether they're helping people in dealing with that something important that they need to do, unless and until they have done their helping bit to a level of satisfaction. That, with respect,
I guess it's a question of degree, and ultimately, if this court should find that not to do so runs the risk of a continued violation of people's rights, then the court may well, without impeding the principle of separation, put in place a mechanism to minimize, possibly to avoid, if that was possible at all, a violation of rights. But I hear what you say. Thank you.
But with respect, Justice Colopin, you need a foundation in law for that, because you are, if you were to be doing that, you would be interdicting governmental executive action, and you would need a basis for saying the right has been made out for an interdict. Now here, no rights violation has been made out for an interdict, and the other elements of an interdict have been woefully inadequately addressed. There's no irreparable harm, and there are alternative remedies. We've set that out in our heads. For the viewers, the alternative remedy, the reason they didn't get their set-top box was that they didn't register. They had 7 years to register, and their obvious remedy was to register. Now, my learned friend, Mr. Motar, made this point a number of times, and I apologize for myself making it as well. There is no evidence anywhere in these thousands of pages of a single person who says, I did not know, I couldn't register, I tried to register and I couldn't. There's no evidence at all of any difficulties of people registering. Unsuccessful attempts to register, didn't know how to register. The closest we get on problems, of evidence of problems, is evidence relating to installation issues. Post office closing, several branches of the post office had closed. Page 415 is where the interveners do that. This has got nothing to do with difficulties in registry. Bear in mind, 1.2 million households had in fact registered before the latest round of last call. That's a lot of people, with great respect. 1.2 million households. We take our learned friends multiple, that would translate into some, 6 million people. That is a third of all the people who, according to that the metric, one of these other metrics where none of these numbers speak to each other because you don't have concentric circles that give you the overlaps, but according to this metric is that a third of all the people who are under the means test. We don't know how many of them actually have STBs. We don't know how many of them have digital television and the like, but a third of all those people have actually registered for, it's a big part of our population. So definitely the idea was out there, and definitely the government is entitled to say, those who wanted this thing have by now gone and got it. Or at the very least, unless we do a step like a last call is tomorrow, or we do a step like saying, if we switch off, then you'll know this is the switch off. I better get up in my STB now. It meets us halfway, buy a ticket. And we have in this situation the extraordinary feature of ETV's own position when it comes to alternative remedies. There was a direct challenge in the papers by Vodacom. It's in our footnote 19.
Mr. Speaker, sorry to interrupt you.
Yes, Mr.
This is a question that I put to your colleague, Mr. Marcus, about the relief that is being sought. It is couched as a declaration, a declaratory order, or an interdict. I'm not sure whether it's an interdict clothed as a declaratory order or vice versa. Yes. And if it's an interdict, one would ask whether the requirements of an interdict, final interdict, have been met or not.
Absolutely.
So what is it that you came to?
Absolutely, Justice Matopo. I heard my learned friend, his only answer to that was it's formulated as a declarator, and that's my story, and I stick to it. Now, with great respect, if I were to formulate my interdicts in future as I declare it is lawful if it is unlawful for you to do X, and I say that's not an interdict, that's just a declarator, then with great respect, I say don't direct them not to do X, because that would be an interdict. Just declare that if they do X, it would be unlawful. That'll just be a declarator. With great respect, this is an interdict. It's a conditional interdict. It says, unless you've done X or Y, you may not have ASO. It is an interdict, and it requires the rigor of interdicts. And that rigor is absent, and the elements have not been made out. Thank you. And with respect to this extraordinary feature of ETV's position, this dialect challenge in the papers was to the effect that ETV had not taken a single step, hadn't done enough, like they accused government of, had not taken a single step to use its own unique channel of communication with its viewers to urge them to register and to assist in this regard. This is not denied in the papers in response. There was a long period of up and down in the High Court on this when it was ultimately conceded that there's nothing in the papers that suggests any such step. I learned that Mr. Mark had said for the first time, he thinks there's something in the papers that says there's such a step. We haven't seen one in the papers, and there is no evidence of any such step. They have done nothing. Now, in subsequent evidence and papers were filed since this issue was hotly debated in the High Court, and there was no attempt in those subsequent papers to say we've done the same sort of thing as we know that the SABC have done, banner headlines and the like and so on. Not a single message by ETV. And we say that this court must decide this matter on the following common sense inference, sorry. If ETV had any desire to have its affected viewers get STBs so they can switch to digital, it would have done everything in its power to make this happen. The fact that it has done nothing at all means it does not suit ETV for its viewers to obtain STBs to facilitate ASO. And I need to say that again. This court must accept it does not suit ETV for its viewers to obtain STBs to facilitate ASO. It would prefer to remain in the analog world with the assistance of this interdict, and instead of competing with the SABC in the digital world, eat up SABC's market share. This ETV itself demonstrates the effect to be of SABC's adhering to the switch off voluntarily while ETV remains on. If I can just refer the court, and I won't read it, but please, with respect, go and have a look at the replying affidavit, paragraph 50.10.3, volume 20, page 2101. A massive shift, they call it a massive shift, and it looks extraordinarily impressive in market share from SABC to ETV during the SABC switch-off process. Shifts in market share of viewers is an enduring phenomenon. It is obviously worth gold to ETV. Now, there is no irreparable harm. This is the most extraordinary feature of this. Those who registered before cutoff date will get STBs before ASO. Those who registered by 10 March will get STBs by September. This is under court order. Those who register afterwards will wait a few months for their STBs. The evidence is that it will happen. It may take time, but access will be subsidized. So the demand that you are faced with in this court is not only for subsidy of access as some sort of socioeconomic right, which remains on the table. That's there. The minister says it's there. I'm not taking it away from anybody, and it will be offered, but for some entitlement to subsidized, seamless, and uninterrupted access. And in the meantime, the critical executive policy imperative of ASO must just wait. Any harm to freedom of expression with respect is tangential and temporary at the very worst. And then when it comes to the interdictory relief, there is this extraordinary problem of the quantitative prerequisite for the interdict. And this is part of the problem that I debated with Justice Colopin earlier. We set out in our heads the extraordinary shifting prerequisites that the appellants have put on that's in our heads of paragraph 32 and following. Originally, the interdict is framed as no ASO until alternative means have been provided to those reliant on analog for their ETV content, i.e. until every analog viewer has an STB. If they'd got that, then one would have had no ASO for probably the next 30 years. This was abandoned by them as childish in the court arquo. This was, however, the basis for the invocation, just bear in mind, of the KZN principle. Their KZN principle invocation is, you promised not a single South African would be left behind. That's how they give content to their KZN principle. Now that's abandoned because clearly with respect it's unattainable, and in their words, it was childish. Now it's turned to, quote, reasonable and justifiable steps. That one gets in paragraph 4.4, which we quote on page 21 of our heads. And we say in our heads, the interveners appear to have forgotten the shift in their heads. There they still seek the terms as originally framed, yet both parties come to this court shifting from everybody gets an STB, everyone who's reliant on analog, to reasonable and justifiable steps. Interdict in those terms. In the replying affidavit to Vodacom, volume 19 at page 2049, that's now from the interveners, paragraph 13.11, there's yet a further quantitative standard suggested by the interveners. They say, nobody really knows what it must be. but it must at least be the overwhelming majority. That's what they say, at least the overwhelming majority. Our learned friend for ETV in this court says, well, we don't know what the standard must be either. We don't know, but it can't be if it excludes, quote, many millions. So there must be a line drawn, interdictory relief. If it excludes, quote, many millions, you're acting unlawfully. If it doesn't exclude, quote, many millions, you're not acting unlawfully. A few million? 1 million? 500,000? At what point does the government start acting lawfully? And at what point is it hit by an interdict, the breach of which hits it with a contempt of court order from this court? These are demanded as quantitative standards to act as the prerequisites for lawful conduct. ASO before them is unlawful and contempt of court, and ASO after them is lawful. So this idea that it is not an interdict and it's framed as a declarator with respect doesn't hold up. Now, how can an interdict, with great respect, how can an interdict be framed in these terms? How can this court issue that kind of order to the government in relation to something as critical as ASO and freeing 700 and 800 for spectrum use? Either the terms are so unachievable as to be abandoned as childish, that's the original terms, or the terms are so unascertainable that nobody could know when they are being transgressed, which is a violation of the basics of interdictory relief demanded by the rule of law. As we all know, an interdict must define with precision what you may not do, so that you can knowingly be in contempt when you do it. The numbers problem severely exacerbates this. This we deal with in our heads at paragraph 50 and following. Now, nobody knows how many people are actually involved. None of these populations talk to each other. There's a group of 36% of this, there's a group of too poor, there's a group who have analog television, but we don't have circles, concentric circles telling us what the overlaps are. They don't talk to each other. The only method of identifying is by asking for registration. With great respect, what else could the government do? It can't embark on a census. It was going to send out a gazillion people to knock on every door. But the interdict isn't framed in terms of populations who register. But there is a fundamental additional constitutional problem with the quantitative threshold that makes interdictory relief so inappropriate. And with respect, that is one of the main points I wish to be able to emphasize to this court today. Again, the Mazibuko case is critical in this regard, and I refer in particular to paragraphs 61 to 68 of that case. In the realization of socioeconomic rights, the court should not prescribe a quantitative threshold below which state action is unlawful and beyond which it is lawful. That has become an entrenched principle in this court when it comes to socioeconomic rights. You cannot prescribe a quantitative threshold where the one side of the line is lawful and the other side of the line is unlawful. That's the main justification for rejecting the minimum core argument. It's based on respect for the separation of powers. This court does not draw the numbers for the executive. This is not the Parliamentary Portfolio Committee on Digital Migration. It must leave that to the executive. Hence, the interdict in this case must be a non-starter on the jurisprudence of this court. And this is the point that, with respect, I had made to Justice Collipan. Any degree of inadequate delivery on any obligation that is found to assist cannot be linked to interdictory relief without a case being made out for an interdict. We can't have a punitive measure that it would be a good way of disciplining better delivery. If I could return to my example.
Sorry to interject. I just need to get clarity on what you're submitting to us.
Yes, Justice.
Am I understanding you to be saying there's no taking away of any socio-economic right to access to information because government says we are going into a new platform, which is digital, for all the good reasons you've mentioned. And we're not simply taking it away. We're saying for you to continue receiving this information, you need to have an STB. If you can afford an STB, come register. We will provide you with one. The only way we can say government is taking away that right, if someone says, I've registered, I'm not getting it away. When ASO comes, I'm not having access to information. Is that the case when you say weaken?
No, with respect, Justice Mlamba, even in that case, no right, especially not the right to freedom of expression, is being taken away. All that would have happened in that regard is that there would have been dilatoriness in the delivery on a commitment to assist with the means to access a certain kind of communication channel. And where in the Constitution does that translate into an actionable socioeconomic right, other than through Section 27 and the right to social assistance, which is for basic needs? But even if it did, it can never translate into an interdict to say if you are in MORA, call it that, you are in MORA with respect to your obligations to assist on the side of helping people deal with the realities of digital migration. You must do more, you must do it more quickly, you must do it in different ways, it's not reasonable, etc. There's no logical and particularly constitutional link between that and saying, ergo, interdict you from ASO. There's just no link. And that's what we...
Thank you very much. Sorry to jut in. I just want to test something else with you. We know from the papers before us that Mnet and SABC have migrated to digital. They've left the analog platform. Yeah. Only ETV. Am I correct?
Well, I think that's how they've left. Mnet have left. The SABC are leaving.
Yes.
So on the papers as they stand, the SABC is committed to leaving. Yes. There was, if I may, I don't want to sound flippant, but there was the wobble, which was the press statement, and which then was led to a retraction. But that wobble, even that wobble, did not translate into a case on the papers that SABC is not switching off. So they are switching off, and Mnet has switched off, and ETV is the only one that is not switching off. Because
that's what I want to ask you. That's what I want to ask you. Do we know, other than the case brought to us, that government is infringing their right to access to information? Do we know if there is any other reason that ETV has of not switching?
We do, Justice Mlombo, and I say that is an inference to be drawn from the papers without my being flippant about it. They want SABC market share. They don't want this to happen. That's why. They don't. If they can get this interdictory relief, then we will not have ASO. They will sit on 700 and 800 for who knows how long, and they'll eat up all of SABC's market share, and that suits them to the ground.
Thank you very much.
Mr. Speaker, your time is up. How much more time do you need?
5 minutes, Justice Chancellor. Two questions. One question is simply that even if there were an infringement, which there is not, obviously in these circumstances, there is more than enough material for a justification under Section 36. And the idea which is floated, and it is linked to this debate about the source of the power, that one isn't dealing with a law of general application with great respect, can't be taken seriously. Whether that source of the power is Section 85(2), which I must stress, one can't read the majority of this court's decision in Mnet versus ETV any other way. That was precisely the problem that the minority had with it. The minority, Mr. Ferreira's argument was that the minority is right. But the court, this court, undeniably found that power is seated directly in Section 85 of the Constitution, or if it is seated in Section 3(1) of the ECA, or if it is seated in Regulation 1 of the digital migration regulations. All of those are easily qualify as laws of general application, which allow them to have recourse to Section 36. And the same would apply, of course, to reasonableness. As far as costs are concerned, if I can just make one point on the invocation of BioWatch by ETV. ETV invokes the rights of others, but it is in effect seeking to promote its own commercial interests. The volte-face that in relation to digital migration, it demanded the speeding up of digital migration. It demanded that in the telecom litigation. It demanded that, which it is now saying should not happen, which is have digital migration by the 30th of June. even the date that the High Court happened to pick was the date that Telkom and ETV demanded digital migration be sped up to. And that volte-face echoes that which so impressed the majority of this court in Mnet and ETV. And the following with respect is also apposite from the majority judgment in paragraph 27 of that decision. It is a constitutional power not to be lightly dislodged by a clamor for consultation, actuated by commercial interests, masked with the appearance of the advancement of public interest. Now, we as Vodacom, with great respect, can't be heard to say, and we don't say, that there's something sinister or strange or weird about coming to court to protect commercial interests. We are also doing that. But if you come to court on the supposed invocation of a public interest or the rights, when what you're actually promoting is a commercial interest, then that principle would apply. And I may point out that in Mnet and ETV, despite a recognition that the constitutional values were invoked, ETV was still ordered to pay Mnet's costs in all courts. That's paragraphs 87 to 88. And we say the same principle should be applicable here. So the appeals against the interdictory orders should be dismissed, and ETV should be directed to pay Vodacom's costs, including the costs of 3 counsel. So I see that in this case, there are armies and phalanxes of counsel, so we have 3.
Mr. Stickers, if I could just ask you one question apropos the main thrust of your argument, which is that there is no infringement of freedom of expression that is at stake in this case. If there were but one television broadcaster, let us just say a broadcaster, the SABC, and everything about this case was the same factually around digital migration, such that many people would be left without access to the sole television broadcaster, would you say that nothing about the right to receive information is impacted in those circumstances?
Even in those circumstances, with respect, you'd have 2 dimensions operate. The one would be the dimension that is sought to be invoked here, which is a reification of a socioeconomic right in relation to freedom of speech, where there is no such right to the Constitution unless you get it through the right to social assistance. And that would apply in the same way if you had only one mode, because what you would be in the hypothesis that I understand you to be putting, the mode would still exist. It would simply be a different technology, and government would have done either not enough.
Is that a fair way of putting it? Because the net effect of the technological platform change or the digital migration change, the effect of it is, in the circumstance I posit to you, that a very large number of people would simply not have access to the only television service that was available. And that would seem to bear upon the freedom to receive information.
But again, what one would at least need there is a conflation of the freedom to receive the information and one very particular mode of enjoying its exercise. In the same way as, for example, with the freedom of movement. If one were to any cost implication of new technology or of movements in relation to policies that make the costs of enjoying something higher, cannot translate into an infringement of that which one is enjoying, of the right that which one is enjoying. That's why I'm saying in the case that you're positing, there would be another dimension, and that's why it wouldn't be lawful. The other dimension in that case would be that you have the obligation on the state, not just statutorily, but in section 192, to promote through a public broadcaster access to various views and a pluralism of views, and you may be able.
Well, that's the Moldova case, which Mr. Marcus cited, yes. And that I think is in a separate category. But
you may be able to argue in that case that if you have a great effect on the effective enjoyment of that particular benefit, you may be encroaching on that obligation, but you still have the conceptual problem, and that's, with respect, one doesn't get away from that conceptual problem. That one cannot, and if this court does anything in this case, it must not turn a socioeconomic right to receive a particular TV content into a socioeconomic right that somehow fits in section 27. Because all socioeconomic rights realize background blue rights.
No, yet, absolutely. My question is posited solely on Section 16.
Yes, so in other words, but there's no reason why Section 16 with respect should be dealt with differently than other blue rights that are impacted upon by socioeconomic rights where one is not giving assistance to the individuals in question to be able to fulfill their better lives and enjoy all the rights of the under the of the Bill of Rights. There's nothing special about freedom of expression that means that if I can't pay for something, because then one would have to say that there must be an obligation to provide televisions, because with respect, that's a big problem conceptually in this whole debate. There's no denying that if they had a right, and if this right were actually being deprived, those who don't have any televisions at all are suffering a greater deprivation of this right than those who are in the position of having a television, the wrong television, but needing an STB. But those
well,
people, nobody is suggesting that there's...
It may be that if freedom is so understood, then all that one would then say is, yes, maybe there is warrant to give very poor people subsidized televisions.
But that is the point with respect. Then we go to that, then we ask ourselves, are we now at a level where there is a socioeconomic obligation to provide people with financial means to be able to watch television?
Well, I think the proposition...
Or to be able to have cell phones. Because
I think the proposition is just this, that the conditions under which the freedom is meaningfully enjoyed actually may require certain positive obligations on the part of the state to make the right properly capable of enjoyment by poor people. I think that's the proposition. I know it hasn't been quite framed that way, but that might be the basis of the claim.
But with respect, as I say, what one is doing when one says that is one is framing a particular socioeconomic right. One is doing that in the face of the jurisprudence of this court that says we have these particular socioeconomic rights. They all address blue rights. And then we have this generic one, which is the right to social assistance. And that generic one speaks to basic needs and to the basic necessities of life. And with great respect, the extent to which those are not being met in this polity is extraordinary. And so it is a little bit odd to be contending for a basic need to a particular kind of television content in that context. But if one were to do that, let us assume even one were to do that, one were to go there. I come back to our point because our point is a concern with the interdictory relief. There is no world in which that can translate into, unless and until you have hit a particular quantitative threshold that satisfies the court in relation to the progressive realization of that particular right, you are not entitled to exercise ASO and to embark on that executive decision, because that even the cases in relation to housing, even the cases in relation to water, in relation to electricity, don't do that. They don't go that far. And so many hurdles need to be jumped over for the fashioning of that right, but it could never translate into interdictory entitlement or to the appropriateness of that interdictory relief that is being sought.
Yes, thank you.
And I must, if I made one last point, we must not lose sight of the fact, if that interdict or anything like it is granted, we will not have 700 and 800 available for cellular telephony in this country for many years to come.
Thank you, Mr. Sneakers.
As the court pleases.
Mr. Mukari.
Thank you very much.
Is it the midnight shift that you are going to do now?
Yes, we're just at the beginning of it, but I will do my best to reduce it for the benefit of everybody, particularly given the fact that Mr. Mutau, for the minister, has really covered much ground, and he has dealt with all the issues that the court wanted him to address. And Mr. Sneakers has addressed the other point which is central to ICASA's concern with this application, which is the interdict disguised as a declaratory order. I am not going to take much time of the court, but I'd like to flag on just a few topics. I'm going to deal with the issue pertaining to registration. And the second issue that I will also address briefly is the fact that the spectrum that ETV desires to cling on has been sold by way of auction. And the third point that I'll also zoom into is what arose during the debate between the bench and Mr. Mutau regarding the date of the 5th of October 2021. I'm going to deal with that in the context of whether this was a reminder to the public, and if so, whether there was an obligation on the minister to remind, and if that translates to a reviewable conduct, if it is found that the reminder was constrained to an unreasonable time for the public to respond. I will then finally deal with the relief that is sought and which was sought in the High Court, which we say was an interdict, particularly given the fact that the order that was given by the High Court is the one that is the subject of an appeal before this court. So this is not an approach to this court by ETV as a direct access and as court of first instance where it seeks specific orders to be granted by this court, but it is approaching the court by way of leave to appeal to this court against a judgment which has already been given by the High Court. So let me start with the first one, the registration. The case of ETV has morphed over time. Today, when we listen to the submissions by Mr. Marcus, he seemed not to take a serious objection or to gainsay what has been put, that is indeed that in order for one to be considered, one must raise up his or her hand. It means that do not hide in the hole, come out of the hole so that we can see you, then you can be assisted. A registration. But the case that was argued strenuously in the High Court by ETV, as well as the other NGOs who are co-applicants, was that there is an obligation on the state based on the promises it made to provide all indigent people who have analog television sets with set-top boxes. That was the case that was argued in the High Court. But now they seem to be conceding, and I also understood Mr. Ferreira to be doing so, that registration is important because that way you are able to know as government how many people you are looking at who are interested. And here we're talking about people who are interested. You may have an analog television, but not interested in an STB. Indigent as you are, because you believe that you can migrate through other mechanisms. So you have to really show up your hand. And this actually ties up with the right that is implicated as put forward by the applicants, underpinned by Section 16 of the Constitution. The question that we have to pose is whether there is a corresponding duty on the public to do something in order for them not to be deprived of their Section 16 right. When you look at Section 16, not all of the paragraphs of Section 16 are implicated by this case. The paragraph that is implicated is paragraph B, which is freedom to receive. And we stop there because it is receive or impart information. We know that the indigents do not impart information when they watch television, they receive. So it is freedom to receive. But then in order for you to receive, what is it that has to be done in the circumstances where the country is migrating from analog to digital, and the technology that is to be used requires some resources for one to migrate? Government acknowledged that not all people are equal in the country, that those who are indigent and poor are unemployed or earning 3,500 or less per month. Those people must be assisted so that they can continue to enjoy their constitutional right to receive information. So what is it that those people must do? Government said that raise up your hands so that we can see how many you are, so that we can get set-top boxes for you. And we know that people did raise up their hands, and government procured set-top boxes for them in order to migrate to digital platform. But we know that they may not be all of them who have done so. There are those who have not raised up their hands. And we should care about the people who don't care about themselves. So what I'm saying is that this right that has to be exercised by the indigent has a corresponding duty on them to raise up their hands so that they can continue to receive information. If they don't raise up their hands, they're simply going to be left out and they will be in the black. And that is a fact. Then we can't then run away from that fact. But they're going to be in the black willingly. This right, it is also juxtaposed with the right that we find in Section 19 of the Constitution. If you look at the right in Section 19, it's the right of citizens to join a political party, to campaign, but most importantly, in subsection 3, is the right for them to vote. And this right is couched in a manner that it says that every adult citizen. So you can actually put it this way and say all adult citizens. But when we go to elections every year, we know that not all of them go to vote because they did not register to vote. Or they registered to vote, but did not go to queue at the polling station. That is the right that they have elected to choose, that we don't want to vote, although the Constitution gives us the right to vote. This court in the IEC case, which involved the proclamation for the local government elections, dismissed the IEC application for this court to postpone local government elections, but it still crafted an order which is just and equitable in the circumstances of that case to say that the minister should proclaim the date or gazette it, and which will ensure that elections takes place by not later than such and such a date. But the application was dismissed. So this is exactly the same type of a case where the High Court correctly, following the principle or what was said as a precedence of some sort by this court, dismissed the application because it had no legal and factual foundation, but because the court was not satisfied that the minister will be able to cover all the registered indigents by the 31st of March, it nevertheless extended the switch-off date to the 30th of June. What the applicants must demonstrate before this court is what is wrong with that order, not to come to this court as if they're asking for a direct access for completely different prayers, as if there is no order that exists. So we submit.
On that point, your protection time is up. You may proceed.
Thank you very much, Justice Nhlanhla. So the point that I'm making is that the High Court did not misdirect itself when it dismissed the application because it lacked factual and legal foundation, but it was correct in exercising its powers in terms of Section 172 by granting an order which is just and equitable to ensure that those who have registered should not be left out. And this comes to the question that was posed by Justice Matopo to Mr. Mutau, that what is to be made about those who have complied with the request or the announcement by the government that by such and such a date, you must make sure that you raise up your hand, you go to the post office, you register your name, and people complied. That is what you call a corresponding duty. They took their time to go to the post office to register. You can't put those people in the same position with the people who didn't care and then they just sat and did nothing. And we must keep on reminding them and say that, can you please come and register? Please come and register. That is not the type of a country that we are looking for. Because in my respectful submission, a country where there is no corresponding duty on the citizens, then it's a country waiting for disaster. We have a plethora of examples. We are in a COVID environment now. People have been saying that government must make vaccination available. When the vaccination came, then people just didn't go to be vaccinated. But that is a choice that people make, and that's permissible, that people will say that, thank you very much, I see that you want me to be vaccinated, but I'm strong enough that I can survive this, and you can't force me to do that. It's their right. So even here, it is a right of citizens who are indigent to say that, yes, we can see you want to help us. Thank you very much. We can actually then migrate on our own, and we don't want your assistance. And this is a classic case of those who have not registered, that they are simply saying so. Justice Unterhalter raised a very important question with Mr. Mutau in the context of, and I just want to move away from the first point of registration to the last but one point about the 5th of October 2021 deadline. The question that Justice Unterhalter raised was the reminders which came from the 5th of October 2021, leading to media announcements by government that people please come forward and so on, you've got 3 weeks and so on. Can that be regarded as sufficient? Of course, the sufficient must depend on the circumstances of each case. But what we don't have here is anybody from the applicants who say that the period that was provided to the public as a reminder through the public media platform was not sufficient and provide the facts to that effect. Like, for instance, there were many people who wanted to register. They were queuing at the post office, and the post office simply closed and said that, look, the 3 weeks has passed. If you give an example with elections where people are standing in the queue, they arrived right on time. There is an opening time for the voting. There is a closing time for the voting. But then you say that you're going to close 10 o'clock, but by that time you still have a long queue of people, and you just close the door, you say that, sorry, it's 10 o'clock now, then we're closed. Then that is unreasonable. Then you are able to say that you have actually deprived people of their constitutional right. We don't have such a case here on the facts where it can be said that people wanted to register after they were reminded, and in fact, they were closed out. Then that was a different case. But we say that on the fact, that's not the case. So on that basis, this court is entitled to infer that the 3 weeks reminder to the public was sufficient to enable those who wanted to receive free set-top boxes from government for free and to register and be counted. And those people can be left out. They have to be given the set-top boxes because government has called upon them to come forward. They came forward, and you can then later on lock them out. So then that's really then the nub of it, insofar as whether the court should be satisfied that sufficient time is being given to people to come forward. We submit that on the facts, the court will find that sufficient time was given to them. Let me link this with the question that was raised. I don't know whether it was raised by Justice Nhlanhla to Mr. Marcus about what did ETV do itself to ensure that it inform its own viewers about the necessity for them to migrate by going to the post office and register, because if they do not do so, they will face a blackout. Mr. Snakas has already informed this court, and I agree with him. I've also not seen any submission or any evidence from the applicants where ETV say that we actually did our part to inform our own viewers. Remember that we are talking here about ETV's viewers. So we're talking about people who have TVs. The only thing is that they've got the analog television sets. We're not talking about people who don't have TVs. There can be even an argument that can be advanced that, well, they did not see the adverts. They did not see the reminders because they don't have TV. ETV is not speaking on behalf of those who don't have TVs. It's speaking on behalf of those who have TVs, and they definitely would have seen that reminder from ETV. It has done absolutely nothing. But what we do know on the fact that the minister did something to inform them and say that, come forward, and we must conclude that they're not interested. They're not interested in to receive set-top boxes because they know that they can take care of themselves. That's the only conclusion that one can reach, unless, of course, the facts which say that they were actually left out because government has done something which impeded them from accessing the set-top boxes. So that brings me really then to what really are we dealing with here, which is different from what the High Court was dealing with. I submit that we're dealing with nothing different from what the High Court was dealing with. The High Court was dealing with an application on a notice of motion where the relief that was sought was couched in a manner that it said that until such time that every single person who has got an analog television set has received an STB, government cannot migrate to
Mr. Mokari, can I ask you about that interdictory relief? Just as a matter of information, we know that there's been a spectrum auction and there have been successful bidders, and particularly for the 700 to 800 bandwidth. What would be the practical effect be for that bidding process and for those successful bidders if, for example, this ASO date is shifted beyond June 2022 to, say, for example, September or December 22 or even later, just on a practical level?
Yes, no, Justice Majid, thanks for that question, because it actually takes me to that topic. Two things are linked to the date of the 30th of June. One is the switch off, that the switch off has to take place in terms of the High Court order on that date. But the second important event that happens on that day is the end of the provisional spectrum. Then at the moment, Justice Majid, we are enjoying this platform and we have very little cut-offs and so on because of the provisional spectrum. That provisional spectrum has been unleashed into the public through the assignment to the same mobile network operators temporarily whilst ICASA was auctioning the spectrum on a permanent basis. So on the 30th of June, that dispensation comes to an end. Automatically, it is replaced by the permanent dispensation according to the allocation or the assignment of spectrum to the bidders who have actually purchased that very same spectrum. So
sorry, can I ask you, Mr. Mokare, as a point of information on that, has that provisional spectrum become available because of the switching off by Mnet in toto and the partial switch off by SABC, or has it got nothing to do with it? Just for information.
Well, at the moment, the spectrum that has been released, on a provisional basis, it is the same spectrum that has been auctioned and purchased, but it is not being used in accordance with the lots that have been purchased until the 30th of June. So at the moment, the operators are using it in accordance with the assignment to them provisionally, including the sub-1 spectrum, which is currently used by the terrestrial broadcasters like ETV. So come the 30th of June, that provisional assignment comes to an end. The sub-1 must then be migrated to the bidders who have purchased that spectrum so that they can use it from the 1st of July going forward. But the difficulty is going to be that they will not be able to use the entire spectrum because in 4 provinces, that spectrum is still used by terrestrial broadcasters like ETV. So that means that it's going to take us back to the pre-COVID time, where now we don't have sufficient spectrum, and we're going to start having the same problems that ICASA is complaining about in the affidavit that it filed in opposition to this application to this court, the drop calls and all those sorts of things. So we're saying that the linking, the tying up of the 30th of June by the High Court was perfect in the sense that it was coinciding with the end of the provisional spectrum and the beginning of the permanent assignment of spectrum. So hence we say that if the court accepts that this application is per se an interdict, then the court would have to now determine whether then it is appropriate in the circumstances where the applicants did not demonstrate the requirements of an interdict, and most importantly, irreparable harm. And now the court has to juxtapose what harm is going to be suffered by ETV and also this indigent people who did not bother to register, as against the harm that is going to be suffered by the general public who will not be able to utilize their technology through the cellular phone data and including voice, which is going to lead to drop calls and unavailability of sufficient spectrum. And if one were to juxtapose, and if we were to say that the interdict sought is interim interdict, then you'll have to deal with the balance of convenience. And I would say that the balance of convenience will favor that this application cannot be granted because the balance of convenience favors that the entire country should now migrate to digital from the 30th of June in order to ensure that we are moving forward and to allow everybody, especially the bidders who have purchased the spectrum, to use it fully and not only partially. And of course, then there is also an important linkage there with the 5 provinces that have successfully migrated. Is this court invited to say that the migration has happened partially and only the remaining part of it must be stalled until when? I don't understand the case of the applicants, because they seem to agree, if you look at the papers, that in 5 provinces migration has taken place. It's only the 4 provinces. But the argument that I'm making is that, well, the remaining 4 provinces actually are the densely populated provinces. And so, but that's exactly the point. The most densely populated provinces are the ones which need high demand spectrum, because then that's where the concentration of people are. And if you are going to ensure that they do not have the capacity to have the sub-1 which has that long propagation characteristics to be able to travel distances and also then penetrate buildings, you're actually taking us then back to pre-COVID time. And is it appropriate and desirable if one looks at it in the context of an interdict? We say that then simply the balance of convenience does not favor the applicants at all in this type of circumstances. So hence we say that we agree with the High Court when it dismissed the application, correctly so, but at the same time, it didn't shy away from exercising its Section 172 powers. It said that, Minister, we are not satisfied on the figures that you have given us that you'll be able to achieve this goal by the 31st of March. Was simply extending it to the 30th of June. What the applicants ought to have done before this court was to demonstrate to this court that the switch-off date of the 30th of June is not achievable in the context of the people who have registered. We're not talking about people who can be verified. We're talking about people who have registered. In the context of people who have registered, will the minister be able to ensure that all of them get set-top boxes? And when I say all of them, I say it with qualification because from those who have registered, others may become impatient and say that, you know what, I'm not going to really wait for the government. I'm going to take my savings or whatever I have, I'm going to migrate myself. So those people who, by the 30th, who still need the STBs, have they been provided with the STBs? If yes, then the minister must switch off. And that takes us back to the issue that was raised by Justice Matopo and also Justice Unterhalter. What must happen if by the 30th of June, not all the people who complied with the request or the invitation by government to register don't have set-top boxes? Of course, and that is an issue that I will submit that the court should leave to the minister, that the minister will then make his or own assessment that as at the 30th of June, do I have all the people? And when I say all reasonable steps being taken to ensure that you reach those people and you found them, others you didn't find them. But that is a decision that the minister will have to take. And if the minister finds that I still have then those who are supposed to get STBs, but they don't have them, then the minister will take a decision there. It doesn't mean that when the minister has taken a decision or then the court order say that it is the 30th of June, that the minister will be in breach of the court order if the minister says that, I think we need 2 more weeks than to finish this report. That will not be breach of the order because it will be a decision that does not take away a right, but it is a decision that in fact confers a right to a party. I mean, when you take a decision that is favorable or confers a right or entitlement to a party, you don't need to consult. When you consult is when the right, when you take something, a decision that is adverse to a person or it is taking away a right. So in those circumstances, I don't think it is even necessary for the court to craft an order to say that we must extend the switch-off date again. But the minister should continue to monitor the progress. And if the minister finds that it is, or there's still a need to cover a certain number of people who have registered and they must be covered, then the minister may say that, okay, I'm supposed to switch off on the 30th of June, but I'm going to switch off maybe on the 5th of July. But the court will not be in a position then to craft an order which will have a specific date in mind. With regard to those who registered after, I think it was after the 11th of October or so, after is it I think 11th or well around October up to the 11th of March, those ones are already catered for by the High Court order, because the High Court order says that they must be provided with set-top boxes and connected to migration by no later than 30 September. So this court does not have to do anything about those ones. They're already protected by the High Court order. And the reason why the High Court order appreciated that the switch off cannot be stalled because of them is because those are people who have already missed the deadline. But the minister is actually then saying that I'm still giving you an opportunity. And I must also make submission that there is nothing which prevents the government to keep the window open, even for those who may still want to come and register. But the only thing is that they will simply be switched on into digital migration, whilst then they were actually kept in the dark first. So it means that you are going to be switched off and you'll be without transmission until such time that you get an STB. And there's nothing then, objectionable to that. Because it's like, if I can go back, to the example of the vaccination. Whilst then there's been government's desire that we must actually have 75% of all adults vaccinated by a certain date. And that date comes, government then doesn't say that, oh, we're not going to provide vaccination to people. Those who still will want to come forward, let them come forward and they'll be assisted. And I submit that there is nothing objectionable with such a process, because we are continuing to deal with a moving target here. As we speak today or yesterday, you may find that there were 200,000 people as they were busy arguing this matter, or now then 100 and something thousand. By tomorrow and so on. So you continue to have this moving target, and the target will continue to move. And I don't think that people are going to stop them to come to knock at government's door and say that, oh, then you know what, we're remiss in our duties. We're supposed to have come for an STB. I thought that I'll be able to get one on my own. I'm not able to. Can you give me one? So government will always be open then to see if it cannot assist those people. But those people do not need the protection of this court in order for them to get those STBs.
Mr.
So
Mukari,
those are submissions ready.
oh, is that your submission? No, I was just about to say your time is up. In fact, I'm happy then when you say those are your submissions.
Yes, then indeed, Justin Chandler. Well, maybe then one last thing that I can also flag is that Mr. Snykers has dealt with it, the KwaZulu-Natal Joint License Committee versus MEC Education, KZN, what is regarded as the KZN principle. In the High Court, Mr. Snykers is correct that this was the trump card of the applicants. The High Court was reminded about the promises that government make under the KZN principle, bound by those promises. But I think that was mentioned, this principle was mentioned maybe 50 times. But today, then I only had it mentioned only twice, but not with vigor. And I'll say that for obvious reasons, because it simply finds no application on the facts of this case at all. And this case was entirely based on the KZN principle. So it means that once then these applicants are not able to defend this principle and to apply it to the fact of this case, then it's the end of this matter. So we submit then to the court that I don't even want to go to how ETV started litigating in this matter. I just wanted to correct what I had Justice Majid saying that there was an order which allowed this auction to take place by Justice Fori, Justice Majid. There was no such order. In fact, when ICASA published the invitation to apply, Telkom took ICASA to court to say that that cannot happen. And one of the reasons that were raised by Telkom was that the sub-1 spectrum is still in the hands of terrestrial broadcasters, and they wanted the process to be stopped and also to be set aside. On the eve of the hearing of that review, which was expedited, Telkom capitulated and withdrew the application. So there was no order of the court which allowed the auction to proceed. The auction proceeded because of the invitation to apply, which was published by ICASA on the 1st of December 2021. So that's also then the correction I wanted to make. Otherwise, then insofar as ETV is concerned, we're entitled to the cost, the same way as the High Court granted us the cost, and we'll submit that the cost of trade counsel will be appropriate. In fact, ETV also asked for the cost of trade counsel in the High Court, and which was appropriate. We say that the cost of trade counsel are appropriate in the circumstances of this case. But insofar as the NGOs are concerned, we were satisfied that they may be protected by BioWash, and we don't seek a cost order against them. We only seek a cost order against ETV. But the application for leave to appeal should be dismissed. If the appeal is, if the leave to appeal is granted, then we say the appeal should be dismissed with cost, as the court pleases.
Thank you, Mr. Mukari. Mr. Rousseau? You said 5 minutes or nothing at all.
Yes, I just want to mention two aspects. I don't think I will be longer than 2 minutes. Justice Matlantla, there is one or two aspects that we want to deal with that hasn't been, or that haven't been dealt with by the other parties. We want to refer the Honourable Court to page 1064, and that is paragraph 352 of the Minister's answering affidavit. And in that regard, we wish to point out, and it reads as follows: the SAB provides programming in the 11 official languages and has 74% penetration, comprising over 30 million listeners. So we're dealing here with a right to receive information. 30 million listeners per radio, obviously, and over 25 million viewers on a weekly basis nationwide. That is another means of receiving information. The other thing that we wish to point out, and that is the last thing that we wish to point out, and that is contained in our heads and also page 25 of the judgment. And that deals with the process of installation, and it says the following: the department achieved the installations completed thus far, and that it was now in March, with 285 installers, and noted that Centec has engaged another approximately 8,000 installers to complete the project. And I think that to a certain extent might address the concerns of Justice Motopu regarding the installation process. And that is all that we want to add to what has already been dealt with.
Thank you very much, Mr. Rousseau.
We do not ask. Yes.
Yes. Mr. Rousseau, you wanted to say something?
No, we will only ask for the application then to be dismissed. We do not ask for a cost order.
Thank you very much. Thank you.
Thank
you. Thanks. Mr. Duplessis, just before you comment, I think Mr. Mutau wanted to give us a report.
Yes, so that the applicants in reply can deal with it. The minister's position is as follows. We don't accept that there is any unlawfulness that has been established or any wrongfulness, and thus entitling the applicants to an order that they seek. The minister is prepared to tender or to file an affidavit within a period of 10 days, which provides sufficient time for other parties to be able to comment thereon, given that we are aiming for the 30th of June.
Unfortunately, just before you proceed,
yes.
The problem is it doesn't give us enough time for the judgment writing. If it's 10 days, then they still have to reply. When then do we get to the actual business of writing the judgment?
Yes, well, Justice Mhlanga, I suppose the court, the court can, the court can indicate a timetable.
It has to be early next week, latest by Wednesday, and the other parties by Friday next week. Not
next
beyond.
week, Wednesday.
Yes, 25 May.
It's 25 May. Yes. Yes, thank you, Justice Ntlantla. And then the one reference that I forgot to give, I was asked by more than one justice regarding public awareness between 2015 and 2022. Just to give one reference so that the applicants can also deal with it. It's in volume 10, pages 1058 to 1067, paragraphs 315 to 363. That deals with the public awareness programs between the period 2015 to 2022. Thank you. Unless there's anything that I need to clarify. So the 25th of May, thank you.
Thank you very much, Mr. Mutau. Mr. Duplessis?
Thank you, Justices. Allow me to start by highlighting what now appear to be two constitutional harms that are common cause, or at least not seriously controverted by the Minister. The first constitutional harm, and as Justice Collipin put it, arises from the fact that the cutoff date has effects, is that the evidence uncontested shows that there are broad classes of analog TV viewers who will lose TV come the ASO, and they count in the millions. And that's the effective result of the argument that we've heard from the Minister today. The facts and the numbers are not controverted. They've been set out in MMA and ETV's heads. My learned friend, Mr. Ferreira, has already drawn attention to some of them, but it is important for the purposes of the court writing its judgment to have regard to at least these paragraphs. MMA's heads, paragraphs 46 to 48, ETV's heads, paragraphs 91 and paragraph 26. But let me argue against myself. Let us assume for a moment that the Constitution permits the Minister to ignore those that didn't meet her 3-week registration deadline. Well, then we're still speaking about millions because, and again, here are the references, in MMA's heads, paragraph 42, and in ETV's heads, in particular, paragraphs 26 and 91, it is highlighted that we're speaking in total about around 2.5 million people who are still going to have to be cared for. Now, that is the class of harm that we are talking about in this case. And we know that we're right because of what Centex heads belatedly helpfully confirm, Justices. As late as they are, they say at paragraph 27, with a very honest concession of those heads, they say, no doubt, they say, an unknown number of indigent households will be inconvenienced for a period of time after the extended ASO date. Well, of course, inconvenienced is a quaint word for violated, but that has at least the virtue of being honest. And we know from what Mr. Mutau said in a concession, a very critical concession in the debates, I think it was with Justice Ntlantla, where he said he accepts that what happens in that 3 to 6 month period will be that people cannot watch television. There will be, as he accepted, a blackout for them. So that is the type of harm we're speaking about for very many millions of people. So if you ask yourself the question at the first principle level of constitutional law, section 38 of the Constitution, leave aside, in other words, all the interesting debates about legality versus administrative action, or whether this is high policy or low policy. At the basic level of section 38 of the Constitution, we know on the evidence that millions of rights are impacted, or at the very least, they are threatened by government action. And under section 38 of the Constitution, those millions of people would have standing to be protected against not just a violation of their rights, but they would also have a standing to have protection against threats thereto, and they'd have a right to remedy. So that's the first constitutional harm, very significant one. The second constitutional harm is this, even on the best case for the minister. Again, this is assuming that the minister is entitled to care only about those that had registered, right? There's still a massive constitutional harm on her own case. And that's because there's no evidence confirming when exactly or how exactly that care is going to be extended to those that registered. I remind you that Centec in its heads of argument in paragraph 27 have said, no doubt, an unknown number of indigent households will be inconvenienced for a period of time after the extended ASO date. And in that context, there was a debate I think largely through Justice Unterhalter, saying, well, perhaps time has moved on. Perhaps time has moved on and we can have the public awareness that took place up until perhaps the sort of period of December counting as some form of amelioration as we stood the argument. But with respect, we think there's a typical problem with that through numbers of features of the Constitutional Court's own jurisprudence. And we say that time has not cured the breach. And that is because Section 172 of the Constitution says that where there's a violation of a constitution, then it has to be set aside. So the original ASO date, which had been set, and for the reasons that have been debated and the court has heard the arguments, if that original ASO date was incorrectly set, unconstitutionally set, then it has to be declared unlawful and set aside. And second principle in this context is that this court has said in Allpay that it doesn't help to say, well, there is going to be an inevitable outcome here, so you don't need to run the process again. The Constitutional Court explained in Allpay at paragraphs 23, 24, and 26 that that type of no difference argument does not apply in our law. The court said the inevitability of a certain outcome is a factor that should be considered in determining the validity of administrative action, is not one that can be taken into account in that type of approach. And you can ask yourself the question at a practical level. The process was flawed at the outset. If it was flawed at the outset, then there may have been a very different result if it was run again properly. We simply have to accept on the no difference principle that that's the basis for why you redo things when they've been shown to be unconstitutional. And let me give you a practical reason for why that must be right. Recall that people were told that they could register at any point in the future and get a set-top box 3 to 6 months after ASO. So having missed that deadline, there would then be no incentive at all for them to register in November or December. In other words, there was no way to shibby them along because already on that basis, they knew, well, we've missed the deadline. So, and we are not going to get a set-top box until 3 to 6 months after ASO. So why would they have been in a hurry to then get the set-top box? That's the reason why you've got to get registration right in the first place, why you've got to have a proper notice and comment process in the first place, because it might have encouraged more people to properly have been incentivized to register. And so that means there's a fourth difficulty with the problem of a December fix-up as the debate unfolded, and that is it doesn't cure the blackout problem. What about those people who didn't register, there aren't set-top boxes, and there is this 3 to 6 months period at least where they are not going to be able to watch their television? It's simply not cured by the debate around a December public awareness campaign. So then that leaves a very significant difficulty for our learned friends, and that is that we know the palliative is set-top boxes. We know that's how the harm will be cured, but we just don't know when the set-top boxes will be rolled out. This court has not been told about two critical features, and I have to stress them. The first is the glaring absence of Treasury approval. There was no evidence that Treasury approval had been obtained for installing set-top boxes for those that had registered after 31 October. And the court will recall the High Court itself was very troubled by that. It said that the government had failed to get Treasury approval to make provision for even sufficient set-top boxes to be provided and installed for those households that had registered after 31 October. In the minister's supplementary affidavit, filed in the High Court on the first day of the hearing, at page 2243 of the papers, it's a critical reference. You'll see that the minister there said, she conceded, she said, we would need to apply for a deviation from the National Treasury to increase the contract scope and value for the required additional installations. This is because the National Treasury has approved installation for registrations up to 31 October 2021. But the number of late registrations was an unknown factor which could not be provided for in the National Treasury approvals. That's critical. The High Court was told that the minister had not yet got Treasury deviations or approvals in place for the extra set-top boxes that would be required. And we don't know then when the minister intends to apply for a deviation. We don't know how long it will actually take to get the deviation. We don't know that. There's not a word from the minister in the heads of argument today, from the council arguing on behalf of the minister. And of course, as was pointed out to the minister didn't file a further affidavit to enlighten the court as to this particular issue. And it's critically important because what we do know about National Treasury, is that National Treasury blocked the 2021 set-top box tender. So one would want to know about whether this deviation is likely to be forthcoming from Treasury, the same Treasury that blocked the set-top box tender. And that's in the founding affidavit, paragraph 205.3 at the papers, page 84, where ETV had said expressly, the department has recently issued a tender for the purchase of set-top boxes, which was subsequently blocked by Treasury. And it cited an article that said as much, and that as a result, those people who are behind in the broadcasting digital migration process will have to wait even longer after National Treasury blocked the transfer of funds allocated for the completion of the set-top box tender. There is no denial by the minister in the answering affidavit. You'll see that at volume 10, at page 1106 to 1107. No denial from the minister in respect of that critical problem. So we still don't know about the issue of deviation. And it is something that, of course, would be a critical feature for knowing whether there is, in fact, going to be the possibility for the minister to meet the rollout of set-top boxes for millions of people. Then there is the difficulty of the rollout rate. My learned friend, Mr. Ferreira, has already highlighted this, that there is a critical problem with the rollout rate, and that it was on the evidence said by MMA and by ETV, and I'll give you the references, MMA's heads, paragraph 44.4, ETV's heads, paragraph 91, and I should add MMA's heads at paragraph 51 and 52, with all of the evidence references in those particular paragraphs. It was made clear there that the rollout rate was simply too slow, and that we were looking at around a 2-year period on the rollout rate on the evidence that the minister provided. In the face of that evidence, the minister would have needed justices to have been very clear and up to date and provide supporting evidence to avoid the risk to rights. Instead, what we had are assertions in the air. The minister says in her heads simply this at paragraph 55.1 and 55.2. She simply says this: these households, those that had registered, and those that registered before 31 March 2022 will be provided, she says, with set-top boxes before 31 September 2022 in terms of the High Court's order. But you'll search in vain for any footnote reference to any portion of the record or pleadings, and you know that, as Justice Mkhlanhla, with respect correctly, and I think also Justice Cheeky pointed out, it would have been obviously critical for the minister to have filed something to explain what it was that was being done about this, so that the court was in a position to know. That's precisely how a responsible government litigant would have attempted to justify these serious problems. But there is no reference. And more importantly, there's no reference and there's no filing of an affidavit in a situation where you have a remarkable feature in this case. Mr. Snickers called it a wobble. It's not a wobble. It's a very serious problem. The SABC has in a statement specifically said that it is concerned about these 4 big provinces that we've all been listening to. We've been talking about these 4 big provinces that lie ahead, that now need to move and have switch off take place. And the SABC said it's because of those 4 provinces that we're particularly concerned about 2 things: the slow progress of set-top box registrations and installations. And the SABC said that presents an unsustainable risk to the rights of millions of indigenous households. Why, said the SABC? Because a premature switch off will deprive millions of people from important public television services. Now, the minister has not denied that SABC's board has said that. And with respect, SABC's board statement is still available publicly on the website. I searched it this morning. It's available there. It's available for anybody to see. So in that context, you have a further significant difficulty, and it's Centec. Their file heads, they could have and they should have attempted to put proper evidence before this court about what the rollout was looking like, how many set-top boxes, how many extra registrations, where the process is. We know that Centec, justices, is central to this process. The minister's answering affidavit tells us that. At paragraph 271, page 1041, the minister tells us that the implementation strategy and plan leading to the restructuring and the roles of responsibilities of entities has led to Centec being appointed to manage installation services, which comprises the appointment and management of installers. And by the way, that's why Mr. Matau, with respect, is not correct to say that people must go and collect at post offices. That's simply not correct. Centec makes it clear, the minister makes it clear at paragraph 274 of that affidavit at page 1042 that the available set-top boxes, the distribution of which is handled by Centec, will be installed in those households. And that will be done.
Sorry, Mr. Du Plessis, can I just ask you this question?
Yes.
You're really dealing with the capacity of the minister to give effect to the High Court order, correct?
No, it's partly that, Justice Colopin.
And the reason I ask this is that do we only get to what you're really dealing with now if we're with you that the minister's decision should be reviewed and set aside? I mean, if we're not with you, then whether the minister complies with the order of the High Court or not is a different issue, not so. It might have ramifications for millions of people, but then that issue is not before us, isn't it?
Well, I suppose the answer is through the realm of understanding Section 38 of the Constitution and the constitutional harms that we say are implicated. So it's precisely because of those constitutional harms that this court's intervention is needed. And I'll draw your attention to Mwelase's decision by this court that speaks precisely about that where there is a clear threat to rights, then the court's intervention is required, and it can do what's required under just and equitable relief to ensure that there is a remedy properly provided. Our argument is to show you that on the uncontroverted evidence, there is a very significant concern around millions of people and their rights. And how's that going to be protected? It has to be protected by this court. That's the answer. And it's not only the case, Justice Colopin, that we're dealing with one or two people's rights. Of course, it's very many. But it's also because there's no attempt by the minister to have explained how she will get set-top boxes to these people in time, or by how and how fast the rollout is going to happen, that the court is left with a situation where it knows that there's a risk. It doesn't know how the minister is going to ameliorate that risk, and it therefore needs to do its duty under Section 172. If I might turn very briefly, and it does necessarily have to be brief, to the question of deference, because it has been flirted with by Mr. Matau and in some respects by Mr. Snickers, saying that this court is not allowed to grant relief because of separation of powers arguments. We've already highlighted, and I think Mr. Marcus made this point, that since TAC, it has been clear that this court has been able to grant a remedy, no matter how high the policy and no matter how the court looks at it, it is enjoined to grant that remedy where rights are implicated. And in that context, the Mwelase judgment is particularly important. It's Mwelase versus the DG for the Department of Rural Development. It's this court's judgment, 2019, Volume 6, SA 597, Constitutional Court. And in that judgment, and of course this court knows it better than us, but in that judgment, the court warned about what it called the bogeyman of separation of powers. And that case too was about a promise and a snag, as the court put it. It was about a promise to provide proper land tenure for labor tenants who had applied for statutory protection by a particular date. And then there was administrative lethargy by the state that did next to nothing to fulfill that promise. And the problem for the court was there was a rights violation, rights were at threat, and the court then said it was faced with this argument by the state in similar context to today, that you can't tell us as the government what to do. This is a policy problem for us to resolve. And the court said in paragraphs 46 to 51, I obviously commend them to the court. The court said two important things, and I'll just lift it out. The first is the court said, in cases that cry out for effective relief, Justice Colopin, in answer to the debate we were having, tagging a function as administrative or executive, though always important, need not always be decisive. Because, said the court, when infringements have occurred, the courts have little choice in their duty to provide effective relief. And that was so in Black Sash, as is the case here. And the court finished that paragraph by saying, it's where the most vulnerable and most marginalized have suffered from the insufficiency of government delivery, then that the court needs to step in. And the court specifically said at paragraph 51, it said, in the same vein, this court is warned in Doctors for Life that the bogeyman of separation of powers should not cause courts to shirk from its constitutional responsibility. So that's why we're saying that the real question is whether there's a constitutional violation that has been shown, an impact on rights, and whether a remedy has been called for. If I might turn then very, very, very briefly again, knowing that this is a reply, to the question of the minister's reasonableness in saying that she was entitled to use registration as some form of proxy. First of all, in that context, we know that if you didn't raise your hand, you weren't counted. But the promise to the poor, justices, and their ability to watch television after ASO, which Mr. Matau has conceded is now going to be blacked out. The promise to the poor and their ability to avoid that blackout depended on how quickly they could sprint to be counted. But the facts show beyond question that it was a race that was beset with problems, not only by the government's prior meanderings, as Justice Unterhalter put it, but it was accentuated by the minister's own making. And in that context, Justice Mkhankala asked our learned friend pertinently, what notice of the 3-week registration of the cutoff was given before the 5 October notice? What was there that the public had ever been told about a 3-week deadline, a hard deadline, which would mean that they would then face the risk of 3 to 6 months of television blackout? And with respect, there's no answer from our learned friends, because despite Mr. Matau providing a reference to what happened from March 2015 onwards and his reference to the post office's statement in May, of course, that is no substitute for a general proper public awareness campaign. There were 1 or 2 notices. That's not a proper general public awareness campaign, certainly not of the type that we saw put into place at breakneck speed from the 5th of October onwards. But here's the critical point. Nowhere did Mr. Matau highlight, because he couldn't, with respect to him, that in any of that period of time, there was ever a notice given which said that there is a hard cutoff, and if you don't register, you will not be able to have a set-top box. And that is why that period of time, that 3-week issue, was so critical. So the minister repeatedly says that the registration window was open since 2015. But again, from Mr. Matau, we heard no answer to what Mr. Marcus has pointed out, which is that the government had stopped installing set-top boxes in January 2019. So the entire process had come to a rest. There was no movement, leaving hundreds of thousands of registered indigent households without set-top boxes for years, even though they'd registered. And the references are critical, and I'd ask the court to go see them, because that's not our evidence, that's the minister's evidence. She says it in the answering affidavit at paragraphs 265 to 267 at page 1040. And you'll see ETV in the replying affidavit at paragraph 44, pages 2093 to 2094, dealing with precisely that. And so what this means is that from January 2019 up until October 2021, registration was evidently entirely pointless. The public generally, and the poor in particular, far from being on alert as to the need to obtain a set-top box to avoid losing television for 3 to 6 months or more, had been lulled into thinking that the process was neutral, if it was alive at all. So registration in that context was not a reasonable proxy, justices, to determine who needed set-top boxes. It was in fact the opposite. It was an unreasonable step that cut off millions of eligible people from obtaining the set-top boxes. And we heard no response either, with respect to our learner friends, to the point that there were obviously less restrictive means available to the state for achieving the outcome of digital migration, a properly managed extended date for ASO.
Before you, Mr. Justice Matopo, your time is up. How much more time do you need?
Justice, I need to just turn very briefly to deal with Vodacom, if I might. So if I could have another 3 to 4 minutes.
Okay. Justice Matopo, you may proceed.
No, can you round up the Vodacom argument? Because that's where I was going at.
Oh, all right, thank you, Justice. In respect to Vodacom, it runs a case, Justices, first and most obviously by taking pot shots at ETV and free-to-air television. But its entire case is divorced from the fact that the SOS and MMA are here in this court making the argument on behalf of the public. And it says that ETV, and it's made this point pertinently and with much vigor, should have started it should have alerted its viewers rather to digital migration by promoting migration. But with respect, that is otherworldly, because there are 2 periods in respect of which ETV can be accused of not taking active steps to promote migration. There's the period before the minister's announcement of 6 October, and there's the period thereafter. But when you look at those periods, obviously ETV's conduct is entirely reasonable. Before the 6th of October, there was no serious indication that ASO was imminent, and ETV had written the 6 letters to the minister trying to obtain clarity on the process, but had received no response at all. So at that stage, the set-top box installation process had stalled, and there was no basis for ETV to think that there was any real or imminent threat to viewers' rights such that it needed to start warning them on television. And in any event, after the 6 October announcement, immediately ETV launched these proceedings on the 17th of October, and it did so obviously recognizing, because it was worried about the process and its unlawfulness, that it needed to be challenged. So to criticize ETV in this way for not having put banner alerts about migration is, with respect, slightly unfair. There's also a very parsimonious approach by Vodacom to free-to-air television. It ignores that this court in SABC versus NDPP emphasized the right of the public to be informed and educated, and it did so specifically by highlighting it through the Broadcasting Act. Justice Unterholt, I think, asked our learned friend, what's the nature of the statutory right? Well, this court said that there is the right of the public to be informed and educated through that type of broadcasting. And so that is where the right resides, and this court recognized it at paragraphs 27 and 57 of the SABC case. Vodacom's argument is then effectively very theoretical. It's a deeply theoretical argument about blue rights, but it never confronts the social reality, justices, of the reality of many millions of South Africans. They cannot afford the means. They cannot afford the new technology. And when ASO comes, because they cannot afford it, they will, because they don't have the means, because they didn't get the set-top boxes, they will be left with a TV blackout, as Mr. Matau rightly concedes. And so with respect, to speak about these blue rights and to talk about a weighing of rights is to miss entirely that there's no getting away from the fact that you can't weigh on the scale people whose rights are going to be denied them, taken away for at the very least 3 to 6 months. And that's why, Justice Colopin, you were, with respect, correct to say this is not a competition between rights. If I might finish on Vodacom's point by highlighting that the public libraries example perhaps is particularly helpful. And I think it was Justice Theron's point. If you think about it, it's like shutting public libraries to promote ebooks as a new technology. So the analogous comparison would be between a company that owns the majority of the ebooks in the country and charges people to use those books versus large swathes of the population who cannot afford ebooks and they cannot access books through libraries. Of course, it would be a retrogressive step to their rights to information if that set of public libraries were closed down. And with respect, this court will look speculatively at an ebook company that comes to court to say, well, don't worry about those people who can't afford the ebooks because ebooks is the future. This court's job is to worry about those people when to know that for 3 to 6 months, they're not going to get books out of a library at all. So if I might finally, very quickly, sorry, Justice Pantla, just make 2 points on remedy, because it is important in light of what we've just heard as well from the Minister. What is entirely missed by our learned friends on remedy is this court's judgment in Chisusa, that's 2020, volume 6, essay 14, CC. That really does put to rest this debate about declarators and interdicts and so on, because this court said, at paragraph 85, the separation of powers principle does not mean that there may not be cases in which this court may be required ipso facto to give directions to the executive. That is required, said the court, after a violation of the Bill of Rights has been shown, and an order is then addressed to the relevant organs of state to do whatever they could to remedy the wrong done or to ameliorate the consequences of the violation, and that would be appropriate. We would be entirely happy with this court if it wanted to recraft the remedy and to fix it in whatever way it thought was appropriate. It can do so, as Mr. Marcus highlighted. For example, it could very happily avoid the interdictory debate by simply declaring that a lawful process of digital migration requires, one, the minister to take reasonable and justifiable steps. That would be an answer immediately. Finally, and this really is the final point, Mr. Snickers made the point, Justice, that if the relief is granted, there won't be access to 700 and 800 bands for years to come. That is simply not so. It's not so on the evidence at all. It's firstly also not so because of what we heard from Mr. Makari, who kept talking about how there is provisional spectrum available. Well, there is. There's provisional spectrum available, but more than that, on the evidence, ETV made it clear, and here are the references, that's in our finding affidavit, paragraph 171.1 at page 71, with reference to ETV's plan, PR 23, which is set out at pages 232 to 253, a very large number of pages, which seem to have been ignored entirely by Mr. Snickers as well as Mr. Mokari, which say that it is perfectly permissible for the ETV and SABT to retain their transmissions which are below 694 megahertz, and which will enable them to continue to offer analog broadcasts to those so long as they are switched over to that below the 7 to 800 band. That is set out in detail. Obviously, don't have the time to take you through it, but it's simply not correct to say that the 700-800 band will be kept up or held up. That's not the position at all. Thank you, Justices, and for the abiding of a little bit of extra time.
Thank you, Mr. du Plessis. Mr. Ferreira.
Thank you, Justice McClantla. I will be very brief because I will not repeat any of the material covered by Mr. du Plessis. Justices, there are really 2 points for me to make. The first was in response to Mr. Mortau's argument in relation to the Section 3.1 and Section 3.5 argument of the Electronic Communications Act. Mr. Mortau argued, in essence, that the determination of the date of analog switch-off was not in itself a policy decision, which would have required consultation in terms of Section 3 sub 5 of the Electronic Communications Act, but was an adjunct to the policy decision, which had been made in the BDM policy, and that those policies, the various iterations and amendments, had been subject to consultation as required. Now, with respect to our learned friends, we understand that submission to be a running aground of his case on the first horn of the dilemma that I posed in chief, because it really amounts to a concession that the nature of this decision can only be administrative action, because it constitutes the implementation of policy, which policy is authorized in terms of statute. And Mr. Mortau quite rightly referred the court to the decision of Mortau, Minister of Defense and Military Veterans v. Mortau and others, the decision of this court in 2014, volume 5, essay 69. And I would just commend to the court in particular, paragraphs 37 and 38 of that judgment, which explains the difference between executive powers, which constitute the making of policy, and the implementation of that policy, which will frequently constitute administrative action. What this court said is that executive powers are in essence high policy or broad direction giving powers. The formulation of policy is a paradigm case of a function that is executive in nature. By contrast, administrative action is the conduct of the bureaucracy, whoever the functionary might be, in carrying out the daily functions of the state, which necessarily involves the application of policy, usually after its translation into law, with direct and immediate consequences for individuals or groups of individuals. And then it says the administrative powers usually entail the application of formulated policy to particular factual circumstances. Once Mr. Mortau submits that the determination of the date of ASO was authorized by the BDM policy, but was adjunct to that policy, it's clear that it was administrative in nature on this test in Mortau, because what the minister did in making the policy was to say, this is the general direction in which we are moving. We must migrate, and minister, you can determine the date of switch off. In determining that date of switch off, what the minister was manifestly doing was applying that policy to the particular facts which were before her. And that's what this court in Mortau said is administrative in nature, the application of policy by the bureaucracy. So if Mr. Mortau's argument is correct and Section 3 sub 5 doesn't apply, Section 4 of PAGA does apply. And so
Mr. Ferreira, excuse me. And how do you understand paragraph 38 of the same judgment?
Yes, Justice Matopo, what that paragraph says is that it says in determining the nature of the power, one must have regard to how closely the decision is related to the formulation of policy on the one hand, or its application on the other. A power that is more closely related to the formulation of policy is likely to be executive, and conversely, one related to its application is likely to be administrative. So we say that simply supports the submission, Justice Matopo.
How does it?
Because when the minister said, we are going to migrate, that is the formulation of policy. When the minister said, and we are going to switch off analog on the...
Don't you look how close that power is?
Yes, indeed. And the selection of a date has nothing to do with formulation of the policy. The formulation of the policy looks at the end goal, which is to get to a position where everyone is migrated onto digital. That's what happened when the BDM policy was formulated.
I don't understand. Excuse me. I don't understand. It would seem like the minister just wakes up and set a date, and then you say, because you've set the date, this administrative. You have to look at the powers, where the power is sourced.
Yes, Justice.
The source of the power is more important.
Justice Matopo, what the court goes on to say is that the source of the power is a useful factor to consider, but it says in paragraph 40 that care must be exercised when reliance is placed on that factor. It says, while administrative powers more commonly flow from legislation, the definition in PAJA expressly contemplates that administrative powers of organs of state may derive from a number of sources, including the Constitution. So yes, the source of the power is indeed important, but it's the nature of the power and not its source which is determinative.
And paragraph 47, on which Mr. Mutau relies on, say something else. Just look at it.
Yes, Justice Matopo, I see that that was the application to the facts of that matter, in which this court found that the decision to dismiss certain functionaries was closer to executive than administrative. But we submit that doesn't...
No, but are we not bound by this decision?
Justice, but that is not authority against the proposition which I'm advancing. It doesn't mean that when the minister selected the date in this circumstance, she was making policy. We submit that what she was doing, and it was particularly apparent in the exchange between Justice Turon and Mr. Mutau, when Justice Turon asked what was in front of the minister when she selected that date. And with respect, she didn't get a meaningful answer. Mr. Mutau was constrained to point to the registration process and a few other facts, but nothing really meaningful in terms of what she considered. What we submit one has to do in determining the date is to have regard in particular to the state of readiness of the country to migrate and the impact of that decision on the indigent. And when one does that, it becomes clear that setting a date is part of the bureaucracy's implementation of the decision, of the policy decision to achieve movement towards a situation where migration has occurred. It's implementation rather than policy formulation, because it's not at the high level of executive functions that the court explained in Mutau is the difference.
Do you have any authority that supports that proposition? I've looked and even now I'm looking at the top of my head. Maybe you can direct my attention to
it. Justice Matopo, I'm not sure which proposition you're referring to.
Well, the one that you're relying on to negate the submission made by Mr. Mutau.
Justice, I'm not. It's not the kind of proposition for which there is authority. I'm characterizing the nature of the decision.
All right. No, thank you. Thank you.
So I would simply go back to those paragraphs of Mutau which we referred to. So, Justices, that is the submission in relation to the section 3.1 and 3.5 debate. The second issue which I must address is Justice Unterholz's exchange with Mr. Mutau and some of our other colleagues in relation to the proposition that one could cure what has happened to date by extending a cutoff period up until, say, December for those who managed to register by that time, and essentially pushing the boat out a little bit more and ensuring that those who registered before December are installed by a particular date. We submit that that proposal would not adequately cure the defects in the registration process that the state conducted. That is primarily because the compression of all of the mass media communications into the end of October, taken together with that unreasonable adoption of a 3-week deadline, undermined the efficacy and constitutional permissibility of everything which followed. And one can see that in those mass media campaigns, that all of those October communications expressly said to people, you must register before the end of October, failing which you'll be out. You can see that. I don't need the court to go there, but it's, for example, at page 1604, where at page 1604, one finds the script for the mass media campaign which government conducted. And what that campaign says is, we encourage everyone to register on or before 31 October, before the analog switch off. If you fail to register before the end of October, you will only be connected within 3 to 6 months after the switch off. And we submit that 3-week deadline, which was communicated to people, fatally undermined the effectiveness of that mass media campaign. And that means you simply can't rely on what has happened up to date in terms of encouraging people to register. Finally, this is just one small point of fact in relation to whether and how far the SABC has already switched off its signal. The SABC has not yet turned off its signal in its analog broadcast in the 4 biggest and most populous provinces in the country. That is, you find it in the minister's affidavit at page 2240. It's a supplementary affidavit before the High Court at paragraph 9. And what one finds is that it's the least populous provinces of the Free State, Northern Cape, Northwest, Limpopo, and Mpumalanga, which have been switched off. And what one infers is that the remainder of the provinces, there continue to be analog broadcasts from the SABC. And so one can't draw any conclusions from the fact that one hasn't seen mass complaints about blackouts in relation to the SABC turning off its broadcast to date. Thank you, Justice Mhlantla. Those are our submissions.
Thank you very much. I'd like to take this opportunity to thank Council for the arguments that they've presented today. But before we conclude, let's confirm that the Minister will file the answering of the affidavit that we spoke of, or by Wednesday, 25 May, and any reply or response to that affidavit, either by the applicant or any party, by Friday, 27 May.
Thank you. Thank you, Justice Mhlantla.
Thank you very much.
Justice Mhlantla, may I have a final submission in response to Justice Matopo's question to me in relation to the question of whether Motau is authority for the proposition I put. Justice Matopo, what I should have said is that if indeed paragraph 47 of Motau means that the decision to set ASO is a policy decision, then it is a policy decision that falls within section 3 sub 1 of the ECA. And so again, the dilemma is not avoided. There's no middle ground. It's either administrative or policy. And if it's policy, it's section 3.5. And if it's administrative, it's section 4. I apologize for not thinking of that at the time that you asked.
Thank you. And judgment is reserved. Court adjourns.
Thank you.
As the court pleases.
Today's proceedings have concluded. The host will